I'm Vinny Politan, lead anchor for Court TV. I always say there's no more dramatic moment on television than the reading of a verdict.
We, the jury, find the defendant guilty of murder in the first degree.
We cover many murder trials, and for the accused, that moment will shape the rest of his or her life. For the victim's family, it's their only chance for justice. Many of our jurisdictions also have the death penalty on the books. So when we're covering a death penalty case, that final verdict is even more dramatic and more compelling for all involved. In that live moment, an accused finds out if he lives or dies for the crime that he committed. The bottom line, Court TV is your front row seat to the American system of justice, and our cameras will take you there.
On count 1 of involuntary manslaughter as to Madison Baldwin, we find the defendant guilty of involuntary manslaughter. On count 2 of involuntary manslaughter in regards to Tate Muir, we find the defendant guilty of involuntary manslaughter. On count 3 as to involuntary manslaughter regarding Hannah St. Juliana, we find the defendant guilty of involuntary manslaughter. And in count 4 of involuntary manslaughter against Justin Schilling, we find the defendant guilty of involuntary manslaughter.
Thank you, Forewoman. You can be seated. And I'm going to please call the jury.
Juror in seat number 1, was that and is that your verdict?
It is.
Juror in seat number 2, was that and is that your verdict?
Yes.
Juror in seat number 3, was that and is that your verdict?
Yes.
Juror in seat number 5, was that and is that your verdict?
Yes.
Juror in seat number 6, was that and is that your verdict?
Yes.
Juror in seat number 7, was that and is that your verdict?
Yes.
Juror in seat number 8, was that and is that your verdict?
Yes.
Juror in seat number 11, was that and is that your verdict?
Yes.
Juror in seat number 12, was that and is that your verdict?
Yes.
Juror in seat number 13, was that and is that your verdict?
Yes.
Juror in seat number 14, was that and is that your verdict?
Yes.
Juror in seat number 16, was that and is that your verdict?
Yes. Thank you very much, ladies and gentlemen. We all know that this is one of the hardest things we've ever done.
Ladies and gentlemen, the jury has reached a verdict in this case. Let me just, and this is not addressed to any particular individual, but it's to everybody involved. We've got people on both sides that care about the verdict. Some of you want it one way, some of you want it another. I have no idea what the verdict is. I will not know until the jury comes in. If the verdict is what you want, what you were hoping for, no celebration is permitted. Okay? It's not a sporting event, it's a solemn event. And I don't want any celebration or hooting or hollering or clapping or anything like that. It's just not the appropriate time or place. Okay? If the verdict is not what any side hoped for, again, if you cannot handle that emotionally, I'll ask you to step outside the courtroom and get the verdict from a friend or companion. Okay? No crying or gnashing of teeth or anything like that will be permitted. And if any of that begins, you'll be asked to leave by one of the officers. Okay? I want everybody to be aware of that, handle that with the appropriate amount of respect for the work the jury has done this week and the work they have done today during their deliberations. So I will ask all of you to honor that request and again, contain your emotions for after the jury is released, and we will receive the verdict here momentarily. All right, the time now is 3:53 p.m. And if there's nothing else to take up, we'll bring in the jury.
All right, we are waiting for the jury to come in. Michael, let me ask you, what is it like as an attorney waiting with a criminal defendant for a verdict?
horrible, especially when you know your client is going to get convicted, because you're going to be on camera standing next to somebody who's convicted, and all that people are going to see is a loss, right? It's horrible. It's terrible. It's nerve-wracking. It's obviously more nerve-wracking when the outcome is in doubt. But in this situation, her attorneys, they know their jury. They live in Tennessee. They live next to these people. They know what the verdict is going to be. So this is maybe a little bit less nerve-wracking for that, in that regard, but it's still very nerve-wracking. And you sympathize with a person after a while, even after the heinous crimes, and then you know that they're going to go through one door and you go through another door. When I was a young attorney getting trained, they told me, listen, don't get too attached to your client, because you go to lunch after you lose. Your client doesn't.
All right, you may be seated.
All right, back to court.
All right, ladies and gentlemen, Mr. Gregg, it's four-person. It's my understanding that you've reached a verdict.
Yes, ma'am.
I will ask you to pass the verdict forms to Mr. Clark so I can review those. Harvey, I'll ask you to stand with your counsel and receive the verdict. Mr. Gregg, as to count one in this case for the offense of first-degree murder by premeditation, I will ask you, did the jury find the defendant guilty or not guilty of the offense as indicted?
The jury found her guilty, Your Honor.
Of first-degree murder with premeditation?
Yes, ma'am.
And did the jury set a fine?
$50,000.
Thank you, sir. I will ask, so say you all. Ms. Dawson, nod yes. All right. The jury for the offense of first-degree murder during the commission of a felony, how did the jury find the defendant?
We found her guilty, Your Honor.
And did the jury set a fine?
$50,000.
Thank you. So say you all.
Yes, Your Honor.
Four-person of the jury for especially aggravated burglary. How did the jury find the defendant?
We found her guilty, Your Honor.
And did the jury set a fine?
$25,000.
You may be seated.
Thank you.
Oh, so say you all.
Yes, Your Honor.
Count through. You may be seated this morning. Just a moment, we'll set the sentencing hearing and some dates for that. Let me just express my personal gratitude for the 6 long days of work that all of you and the alternates that were excused have put into this case.
Mr. Foreperson, it's the court's understanding that the jury has reached a verdict in this matter.
That's correct.
As to charge ID 193-794-7C, charging the defendant, Adam Montgomery, with the crime of second-degree assault, do you find the defendant guilty or not guilty?
Guilty.
You say that he's guilty, Mr. Foreperson?
That is correct.
So say you all, ladies and gentlemen of the jury?
Yes.
As to charge ID 202-7112C, charging the defendant, Adam Montgomery, with the crime of second-degree murder, do you find the defendant guilty or not guilty?
Guilty.
You say that he's guilty, Mr. Foreperson?
That's correct.
So say you all, ladies and gentlemen of the jury?
Yes.
And as to charge ID 202-7113C, charging the defendant with the crime of falsifying physical evidence, do you find the defendant guilty or not guilty?
Guilty.
You say that he's guilty, Mr. Foreperson?
That's correct.
So say you all, ladies and gentlemen of the jury?
Yes.
And on charge ID 202-7114C, charging the defendant, Adam Montgomery, with the crime of abuse of corpse, do you find the defendant guilty or not guilty?
Guilty.
You say that he's guilty, Mr. Foreperson.
That's correct.
So say you all, ladies and gentlemen of the jury?
Yes.
And on charge ID 202-7115C, charging the defendant, Adam Montgomery, with the crime of tampering with witnesses and informants, do you find the defendant guilty or not guilty?
Guilty.
You say that he's guilty, Mr. Foreperson.
That's correct.
So say you all, ladies and gentlemen of the jury.
Yes.
Thank you.
Ladies and gentlemen, I want to thank you for your service. You've performed an important civic duty, and that is as to the alternates as well as all the deliberating jurors. What we're going to do now is I'm going to send you back into the deliberation room. The alternates are going to be able to go back now with you. You can discuss the case with each other, so it's an opportunity for you to do that. I'm going to take a few minutes with the lawyers here, and then I will come in to discuss a couple of other matters with you further, and then you'll be released from your service. All right? Thank you so much, ladies and gentlemen. All rise for the jurors, please.
All right, there you go. Guilty on all counts. Adam Montgomery, not there to witness it, but Crystal Sorey was there, Harmony's mother. Packed courtroom. You see Matt Johnson's there. This is the way the system works, and boy, it did work. And Julia, we were talking, both sets of attorneys were fantastic in this case. The prosecution, their closing was just off the charts, how impactful it was, but also the defense. I mean, the defense was given a very difficult set of cards, and
their job is what hangs everything in the
seated.
balance. Let's listen to the judge.
Counsel, we just need to schedule sentencing. I don't know how much time the parties feel that they need.
We'll say we are scheduled here on Thursday the 2nd of March for this stuff.
Will both sides be prepared? Actually, I don't know what the court may not have sufficient time that day, so let me just look. No, I'm actually going to be in trial that day. I have a docket in the morning, but I'm in trial after. It may be that maybe we could just get some time frame. Let me look to the state first about how long do you need to be prepared? And I'll have...
We may need to at least go a little bit of time beyond that. I would say, sorry, I'm just looking at my calendar as well.
Better not to give me a date. Just tell me about how far out and about how much time you think you'll need.
I think, Your Honor, we're going to need roughly 4 weeks, so somewhere around the last week of March, first week of April.
Okay. So sometime after April 1st. I know I'm going into a lengthy trial in April, so we'll see what we can do. About how long a hearing do you feel that you'll need?
Based upon my best estimate, Your Honor, is probably at least half the day, so at least a solid 3 hours. Would be the safest time period to go. If we use less of it, we use less.
Okay, just knowing what the court's docket is, and then I know I have a 3-week trial also in April, it may not be possible to get it in that month, but we'll do it as quickly thereafter as we can, as long as that's sufficient for the defense.
Putting us into May, certainly plenty of time.
Okay, if there are other constraints, please let the court know. Otherwise, we'll schedule it as the docket permits in sometime after April 1st. Is that okay with you?
Yes.
Okay.
We have jury trials to work around, but smaller.
Okay. All right, I'm not inclined. I know the parties are preparing sentencing memos. I'm not inclined for a PSI unless somebody feels that one would be needed. No? Okay, very good. Sentencing memos, any sentencing memos should be in, I would say, given the time frame, if you can sentencing memos in 10 days in advance, that would be helpful to the court. That will give time for the court to consider any information, ample time to consider any information the court needs to consider. Anything else we need to accomplish today?
I think, Your Honor, just from the state's perspective, when we do have the sentencing date and we're getting closer, the state will ask under RSA 651:4-A that the defendant, whether he likes it or not, will have to be transported here for the sentencing pursuant to that statutory authority.
Okay. If you're going to file something, did you say?
File that, Your Honor.
Okay.
There's very clear statute on it. There's case law on it. We will provide that to the court ahead of time and do that in plenty of time so that the defense can respond to that before we get anywhere near that 10-day mark.
ahead of the hearing. Okay. Anything else the defense wants to raise?
Not at this time, thank you.
All right, thank you, everybody.
Thank you.
All right.
Okay, there it is. Boy, courtroom is packed. Michael J. for watching along with us. No surprise, I guess. It would have been a shocker had they found him not guilty, but still, it took him a little longer than we thought. As we see the defense leave.
Sorry, Ted. Sorry I had a lag. Yeah, no, it's the end of an era, my friend. It's the end of an era. We've been covering this case for a long time. And the crescendo at the end was, surprising to me. The fact that the jury took that much time. I mean, I respect that. I wish all jurors, all jury pools, take time and weigh everything and go through everything. There have been many times in my experience, and just in covering cases on Court TV, where juries come back alarmingly quick and you kind of feel offended, right? You kind of feel slighted. You say, hey, so many people put so much into this case. There's so much, so much there for you to look at, but you came back in 3 hours, right? But in this situation, we were shocked that they did not come back in 3 hours. So it's kind of a fitting end and a culmination to this whole entire process. And Adam Montgomery, God bless you, buddy. You caused all this. You've now been found guilty, do your thing, I guess.
This is a moment for this community, Michael. I mean, we're seeing there the hugs, the camaraderie between law enforcement, the victim's family, the prosecution there walking out. A job well done to them in this. I mean, this is a case where the governor of New Hampshire called Adam Montgomery before this conviction a monstrous drug dealer who should have never had custody of Harmony. So there's been a lot of investigation following this case that goes far beyond just this trial, this murder case.
I will read the forms, the verdicts. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the first degree as charged in count 1. Verdict 2. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the second degree as charged in count 2. Verdict 3. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the second degree as charged in count 3. Verdict 4. We, the jury, find the defendant Brian Stephen Smith guilty of sexual assault in the second degree as charged in count 4. Verdict 5. We, the jury, find the defendant Brian Stephen Smith guilty of sexual assault in the second degree as charged in count 5. Verdict 6. We, the jury, find the defendant Brian Stephen Smith guilty of tampering with physical evidence as charged in count 6. Verdict 7. We, the jury, find the defendant Brian Stephen Smith guilty of tampering with physical evidence as charged in count 7. Verdict 8. We, the jury, find the defendant Brian Stephen Smith guilty of tampering with physical evidence as charged in count 8. Verdict 9. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the first degree as charged in count 9. Verdict 10. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the second degree as charged in count 10. Verdict 11. We, the jury, find the defendant Brian Stephen Smith guilty of murder in the second degree as charged in count 11. Verdict 12. We, the jury, find the defendant Brian Stephen Smith guilty of tampering with physical evidence as charged in count 12. Verdict 13. We, the jury, find the defendant Brian Stephen Smith guilty of tampering with physical evidence as charged in count 13. In count 14, we, the jury, find the defendant Brian Stephen Smith guilty of misconduct involving a corpse as charged in count 14. You may be seated. Master Clerk, would you please poll the jury?
Juror number 1, is this your true and accurate verdict? Juror number 2, is this your true and accurate verdict?
Yes.
Juror number 3, is this your true and accurate verdict?
Yes.
Juror number 5, is this your true and accurate verdict?
Yes.
Juror number 6, is this your true and accurate verdict?
Yeah.
Juror number 7, is this your true and accurate verdict?
Yes.
Juror number 8, is this your true and accurate verdict?
Yes.
Juror number 10, is this your true and accurate verdict?
Yes.
Juror number 11, is this your true and accurate verdict?
Yes.
Juror number 12, is this your true and accurate verdict?
Yes.
Juror number 14, does this return an accurate verdict?
Yes.
Juror number 15, does this return an accurate verdict?
Yes.
Thank you.
Jury verdicts have been returned in their proper form. The court has polled the jury and the verdicts are unanimous. The court accepts the jury's verdicts. Folks, there's a little bit more work to do. Now that you've found the defendant, Brian Stephen Smith, guilty as to count 1, murder in the first degree, you must consider whether a special circumstance called an aggravating factor applies to this count. The defendant is presumed innocent of the alleged aggravating factor as set out in instruction number 51 that I'll be giving you. The state has the burden of proving this aggravating factor beyond a reasonable doubt as set out in instruction number 51. The proceedings will be similar to trial. The state will have the first opportunity to, my understanding is there isn't going to be new evidence. Is that correct, counsel?
That's correct, Judge.
So that it'll be argument and the state will have the first opportunity to argue. The defense may choose to respond then, but does the defense have any evidence to present? Okay. But the defense will have a turn to argue and then the state will have a final rebuttal argument if they want that or need that.
Ladies and gentlemen of the jury, in the case of the state of Connecticut versus Michelle Troconis, have you agreed upon a verdict?
Yes.
Will the foreperson please rise and identify himself? Everyone else can sit, have a seat. Will the defendant, Michelle Troconis, please rise and face the jury? In file number FST CR 200241178T, State of Connecticut versus Michelle Troconis. What say you, Mr. Foreperson? Is she guilty or not guilty of the first count of the information charging the defendant with conspiracy to commit murder in violation of Connecticut General Statutes, Section 53A, 48A, and 53A-54A, subsection A?
Guilty.
What say you, Mr. Foreperson? Is she guilty or not guilty on the second count of the information to the charge of conspiracy to commit tampering with physical evidence in violation of Connecticut General Statutes, Section 53A-155, subsection A, subsection 1?
Guilty.
What say you, Mr. Foreperson? Is she guilty or not guilty on the third count of the information to the charge of tampering with physical evidence in violation of Connecticut General Statutes, Section 53A-8, subsection A?
Guilty.
What say you, Mr. Foreperson? Is she guilty or not guilty on the fourth count of the information to the charge of conspiracy to commit tampering with physical evidence in violation of Connecticut General Statutes, Section 53A-48, subsection A, and 53A-155, subsection A, subsection 1?
Guilty.
What say you, Mr. Foreperson? Is she guilty or not guilty on the fifth count of the information to the charge of tampering with physical evidence in violation of Connecticut General Statutes, Section 53A-8, subsection A?
Guilty.
What say you, Mr. Foreperson? Is she guilty or not guilty on the fifth count of the information to the charge of hindering prosecution in the second degree in violation of Connecticut General Statutes, Section 53A-165, subsection A, subsection 3, and 53A-166?
Guilty.
You ladies and... I'm sorry, one moment. The court will then accept the verdict.
The verdicts are accepted and recorded.
All right, this is the verdict of the jury in indictment number 24-CR-1183, State of Georgia versus Eligio Bishop. On count 1, how does the jury find? Count 1 is rape.
Guilty.
And count 2, false imprisonment. Guilty. Count 3, prohibition on nude or sexually explicit electronic transmissions.
Guilty.
Count 4, prohibition on nude or sexually explicit electronic transmissions.
Guilty.
And count 5, prohibition on nude or sexually explicit electronic transmissions.
Guilty.
All right. And it is signed and dated by you as the foreperson.
Correct.
Thank you very much. All right. I'm going to have the deputy provide the verdict form to the state and to the defense for them to review.
I said, ladies and gentlemen of the jury, through the foreperson, have you reached a verdict?
Yes.
All right, and do you wish to read the verdicts?
Sure.
Okay. I would start with count 1. Okay. You have both of them. Will the defendant please stand?
We find the defendant, Hannah Gutierrez, guilty of involuntary manslaughter as charged in count 1. We find the defendant, Hannah Gutierrez, not guilty of tampering with evidence as charged in count 2.
All right, thank you. You may be seated. Let me get those forms, retrieve those forms from you. I'm going to do what's called polling the jury. What I need to put on the record is that this is your individual verdict, okay? So I'm going to start with the gentleman in the back. Is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes, Your Honor.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict? Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict? Okay, thank you. All right, so you've completed your service. Thank you so much for being here. It was a long trial.
I understand the jury has reached a unanimous verdict as to each of the counts contained within this indictment. Is that correct?
Yes, sir.
If you would stand, please, sir. Ms. Howington, if you would stand and remarks as to the first count of this indictment charging first-degree felony murder, as the jury reached a unanimous verdict.
Yes, we have, Your Honor.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of reckless homicide.
As to the second count, alleging aggravated child neglect, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of aggravated child neglect.
As to the third count, alleging aggravated child neglect, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of aggravated child neglect.
As to the fourth count, alleging, initiating, or filing a false report to law enforcement, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of initiating a false report to a law enforcement officer.
As to the fifth count, alleging tampering with evidence, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of tampering with evidence.
And as to the sixth count, alleging attempted tampering with evidence, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury, find the defendant, Rebecca Howington, guilty of attempted tampering with evidence.
If that is your verdict, if you would signify by raising your right hand, please. Let the record reflect all 12 hands are raised. Does either side wish for the court to poll this jury?
Your Honor.
All right, Ms. Howington, you may have a seat. Ladies and gentlemen, thank you very much for your hard work. You have concluded week 1 of your jury service. I wish I could tell you that you're done, but you're not. You've still got 1 more week of service. I know that we've got another case to start in here on Monday, so I'm sure I'm going to see a lot of you back on Monday morning when we're picking another jury. Have a very good weekend. Thank you very much for your service, and I'll see you on Monday. All rise for the jury.
All right, the jury is exiting there in Knoxville, Tennessee. Michelle Thomas, you're still with us. It appears guilty on all counts. What's your reaction?
No surprise here. Her story just didn't add up. Saying that she was trying to protect her 2-year-old, that doesn't make any sense. So she certainly was, this was an expected outcome.
All right, let's listen in.
Aggravated child neglect, count 4, filing a false police report, count 5, tampering with evidence, and count 6, attempted tampering with evidence. The court revokes your bond. You're ordered into custody. When do we need to set this for sentencing? What's 45 days?
April 22nd.
April 22nd. What day of the week is that?
That's fine, Monday.
That preceding Friday would be what, the 19th? Does Friday, April the 19th work for everyone for sentencing?
Yes.
Is that good, General? Ms. Howington, I will see you on April the 19th. The court will conduct a sentencing hearing at that time. In the interim, a pre-sentence investigation report will be prepared. Probation will be interviewing you if you wish to have your attorney present with you. When that interview is conducted, you have a right to do so. I'll see you on April the 19th.
All right, this is in the people of the state of California in the county and for San Diego. The people of the state of California versus Jesse Milton Alvarez, case number SCD 288940. Verdict count 1, we, the jury, in the above entitled cause, find the defendant, Jesse Milton Alvarez, guilty of the crime of murder in the first degree in violation of Penal Code Section 187A as charged in count 1 of the information and fix the degree thereof as murder in the first degree. And we further find the defendant, Jesse Milton Alvarez, true in that he intentionally and personally discharged a firearm, to it a 9mm firearm, and approximately caused the death of Mario Fierro within the meaning of Penal Code Section 12022.53 parens D. And we further find that the murder of Mario Fierro was committed by defendant Jesse Milton Alvarez, true, who intentionally killed Mario Fierro by means of lying in wait within the meaning of Penal Code Section 190.2A, parens 15. This is dated today's date and signed by Juror 6, the presiding juror. I'll also note for any appellate record that the verdict forms, the remaining verdict forms, were not filled out as required under 640. All right. Does either side want to poll the jury? All right, very good. Madam Clerk, can you please record the verdicts? Does counsel waive reading of the verdicts as recorded?
Yes.
All right.
Gentlemen, I know you've worked very hard. We've all been awaiting your decision. I know this was a very intense decision for you all to make. I believe you've selected a foreperson. Who's the foreperson? You're the foreperson. Could you read the verdict, please?
Each count?
Sure.
Count 1, involuntary manslaughter as to Madison Baldwin, guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Meir, guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana, guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling, guilty of involuntary manslaughter as to Justin Schilling.
Thank you, foreperson. I'm going to ask that Ms. Williams poll the jury. So she's going to ask you each.
Jury in seat number 1, was that and is that your verdict?
Yes.
Jury in seat number 2, was that and is that your verdict?
Yes.
Jury in seat number 3, was that and is that your verdict?
Yes.
Jury in seat number 4, was that and is that your verdict?
It is.
Jury in seat number 6, was that and is that your verdict?
It is.
Jury in seat number 7, was that and is that your verdict?
It is.
Jury in seat number 8, was that and is that your verdict?
It is.
Jury in seat number 9, was that and is that your verdict?
It is.
Jury in seat number 11, was that and is that your verdict?
It is.
Jury in seat number 12, was that and is that your verdict?
Yes, it is.
Jury in seat number 13, was that and is that your verdict?
It is.
Jury in seat number 14, was that and is that your verdict?
It is. Thank you, ladies and gentlemen. I know how hard this has been on all of you just by reading your face.
The jury in Idaho has reached a verdict in the jealous ex-trooper murder trial in Idaho. The jury deliberated for 8 hours, 19 minutes. There you see the judge, Daniel Howard, accused of killing his wife, Kendi, back in 2021, but he claimed it was suicide. We are going to take you in live now because it seems that the judge is standing. They usually stand as the jury enters, which means this verdict is on its way, folks. Let's listen in.
You may be seated. Members of the jury, I'll ask you to speak through your foreperson. Who is that? All right. Have you in fact reached a verdict? Yes, we have. All right. If you would hand the verdict form to my bailiff, please. Mr. Howard, if you'd please rise. The clerk will read the jury's verdict.
In the District Court of the 1st Judicial District of the State of Idaho, in and for the County of Kootenai, State of Idaho versus Daniel C. Howard, we, the jury, duly impaneled and sworn to the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Count 1, is the defendant Daniel C. Howard guilty or not guilty of domestic battery? Guilty. Count 2, is the defendant Daniel C. Howard guilty or not guilty of murder in the first degree? Not guilty. Is the defendant Daniel Howard guilty or not guilty of second degree murder? Guilty.
And I'll note it's signed by the presiding officer. Members of the jury, is this in fact your verdict, so say you all? Yes. All right. Do either of the attorneys wish to have the jury polled? No. All right. Members of the jury, I'll tell you what happens next. I'll set this matter for sentencing. Mr. Howard is remanded into custody. Counsel, I'm proposing a sentencing date of May 23rd at 1:30 p.m. That's available. I will order a PSI or a pre-sentence investigation. Mr. Howard, I'll have you talk with your attorney about that. You have the right to participate or not participate in that. You continue to have the right to remain silent. Members of the jury, I'm going to read you a closing instruction. I've given you a lot of instructions during this case. You have now completed your duties as jurors in this case and are discharged with the sincere thanks of the court. The question may arise as to whether you may discuss this case with the attorneys or with anyone else. For your guidance, the court instructs you that whether you talk to the attorneys or to anyone else is entirely your own decision. It is proper for you to discuss this case if you wish to, but you are not required to do so, and you may choose not to discuss the case with anyone at all. If you choose to, you may tell them as much or as little as you like, but you should be careful to respect the privacy and feelings of your fellow jurors. Remember that they understood their deliberations to be confidential. Therefore, you should limit your comments to your own perceptions and feelings. If anyone persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it back to me. And with that, I want to thank you for your patience, for your attentiveness, your conscientiousness and attention to detail throughout this case and the time that you gave in service to this case. I thank the attorneys again for their professionalism and excellent advocacy. All right, I will excuse the jury at this time, and please stand for the jury.
Big news tonight. Daniel Howard guilty of second-degree murder. The jury has spoken. It was not suicide. This was murder. Now you know why he was at the airport. He knew what was coming. He heard the evidence. A big night. Former state trooper guilty of murdering his wife of 25 years. They are in the midst of a divorce, so the motive there was obvious. Things were not great between the two, but you could see he's getting cuffed. On the other side of the law now, it's not easy in prison for former police officers, and that's where he's going. Former Idaho State Trooper, justice delayed but not justice denied. The jury coming back with guilty of second degree, not first degree. It was not guilty of first degree, but guilty of the second degree, along with the domestic battery. Looks like the judge has left the bench. Everyone is gone. So this verdict is in. This verdict is final for now. So again, breaking news, Dan Howard, guilty of murdering his wife, Kendi, his estranged wife. They were getting ready for a divorce after 25 years together. You wonder, why would you do that? Someone you spend 25 years of your life with, a good majority of your life with. And some people, they don't want to split the money. They just want out. They want a new life. I'm tired of you, whatever it is. But it's unforgivable. And today the jury spoke, and they spoke loudly.
All right, Madam Foreperson, ladies and gentlemen of the jury, hearken to your verdict as the court will record it. On indictment 19 CR 168, count 1 charging murder, you upon your oath say the defendant is guilty of murder in the first degree by reason of extreme atrocity and cruelty. So say you, Madam Foreperson?
Yes.
So say you, ladies and gentlemen of the jury.
Yes.
Has this verdict been unanimous? Count 2, charging assault and battery by means of a dangerous weapon, you upon your oath say that the defendant is guilty. So say you, Madam Foreperson?
Yes.
So say you, ladies and gentlemen of the jury.
Yes.
Has this verdict been unanimous?
Yes. Yes.
Thank you. You may be seated. Sir, you may be seated.
Juror number 7, would you please stand up and read the verdict form?
Yes, ma'am. Okay. So on count 1, we the jury find the defendant guilty of second-degree murder. On count 2, we the jury find the defendant guilty of dead bodies, disinterment, and mutilation.
Thank you. Please be seated. Juror number 1, was that your verdict?
Yes.
Juror number 2, was that your verdict?
Yes, it was.
Juror number 4, was that your verdict?
Yes.
Juror number 5, was that your verdict?
Yes.
Juror number 7, was that your verdict?
Yes.
Juror number 8, was that your verdict?
Yes.
Juror number 9?
Yes.
Juror number 10, was that your verdict?
Yes, ma'am.
Juror number 11?
Yes, ma'am.
Juror number 12?
Yes.
Juror number 13, was that your verdict?
I was 14, but yes.
Oh, yes, okay. Ladies and gentlemen, I can't thank you enough on behalf of Eaton County, on behalf of the prosecutor and the defense, and on behalf of myself. This was a long trial. Yeah, there were many exhibits, many witnesses, and it was very difficult. And I greatly appreciate the service that you have performed. I would ask that you just wait a few minutes back in the jury room, and I'll be back to talk to you.
All rise for the jury.
Madam Foreperson, would you please stand? Madam Foreperson, it's my understanding that the jury has reached a verdict on each of the charges before it. Is that correct? And is the jury's verdict unanimous on each of the charges?
Yes, it is.
At this time, I'm going to ask the clerk to take the verdict, and she'll do so by following through the verdict form that you have. Please respond to her questions. Madam Clerk?
Good afternoon, ma'am. As to charge ID number 143-85153, charging the defendant with the first degree murder of Christine Sullivan, as the jury finds the defendant guilty or not guilty, as to charge ID number 143-85163, charging the defendant with the second degree murder of Christine Sullivan, as the jury finds the defendant guilty or not guilty, as to charge ID number 145-85164, 8519C, charging the defendant with falsification of physical evidence, concealing the body of Christine Sullivan. How does the jury find the defendant guilty or not guilty?
We find him guilty.
Is that the verdict of all of you? As to charge ID number 1438520C, charging the defendant with falsification of physical evidence, concealing the body of Jenna Pellegrini. How does the jury find the defendant guilty or not guilty?
We find him guilty.
Is that the verdict of all of you? As to charge ID number 1438521C, charging the defendant with falsification of physical evidence, altering blood stain on exterior porch. How does the jury find the defendant guilty or not guilty?
We find him guilty.
Is that the verdict of all of you? As to charge ID number 1438522C, charging the defendant with falsification of physical evidence, concealing blood-stained sheet and personal belongings in a black trash bag. How does the jury find the defendant guilty or not guilty?
We find him guilty.
Is that the verdict of all of you? And finally, as to charge ID number 1438523C, charging the defendant with falsification of physical evidence, concealing blood-stained items in a clear trash bag. How does the jury find the defendant guilty or not guilty?
We find him guilty.
Is that the verdict of all of you? Thank you, ma'am.
All right, we are back in session on the record in State of Wisconsin versus Nicolae Mew. The attorneys are present with Mr. Mew. 12 jurors are in the courtroom. Mr. Ashland, I understand you are the foreperson.
Correct.
Did your jury reach a verdict?
Yeah.
Did you reach a verdict on each of the 6 counts?
Yes, we did.
Okay, please hand the verdict forms to the bailiff. The verdicts read as follows. As to count 1 of the information, Isaac Schumann, the jury finds Nicolae Mew guilty of first-degree reckless homicide as submitted. Question, did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 2 of the information, Alexander Martin, the jury finds Nicolae Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 3 of the information, Dante Carlson, the jury finds Nicolae Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 4 of the information, Anthony Carlson, the jury finds Nicolae Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 5 of the information, Riley Madison, the jury finds Nicolae Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 6 of the information, Madison Cohen, the jury finds Nicolae Mew guilty of battery as charged. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. Members of the jury, I do have to verify that this is in fact a unanimous verdict. So I'm going to ask each of you if I correctly read the verdict and if you agree with it. So when I call your name, if you agree with the verdict that I read, please answer by saying yes. If you disagree with the verdict, you can answer by saying no. Ms. Navarro, do you? Mr. Snell, do you?
Okay, guilty, but not on the top charge.
The lesser included charge of first-degree reckless homicide and first-degree endangering of safety. That's for those who were stabbed but survived. There were 2 levels under 3 levels rather, under first-degree intentional homicide. They either could have come back with second-degree intentional homicide. They didn't. They went with first-degree reckless homicide, which comes under that, and they also had the option of second-degree reckless homicide. They didn't go for that lowest of the lesser includeds, but really right in the middle.
Yeah, and this sentencing will be key, whether these are served concurrently or not. They're done polling the jury. Let's go back in and listen to the judge.
It's completed. You are free to read accounts about this trial. You are free to talk about this case with anyone. However, you do not have to discuss this case with anybody or answer any questions about this case other than from the court. So this includes the parties, the lawyers, the media, or anybody else. If you do decide to discuss this case with anyone, please treat any such discussion with a degree of solemnity, such that whatever you would say, you'd be willing to say in front of your fellow jurors or here in open court. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or the public. For that reason, please respect the privacy of the views of your fellow jurors. If you do decide to speak, please only speak for yourselves and not for anybody else. On behalf of my colleagues, Judges Needham, Vlack, and Nordstrand, along with my courtroom staff, thank you for your participation in this important case. Court is now adjourned. Please take the jury out.
All rise for the jury.
Please be seated. Based on the unanimous verdict, I will enter convictions on each of the 6 counts. Bail is revoked. Mr. Mew will be held in custody pending sentencing. My staff will contact the attorneys and will schedule the sentencing date. I will order a pre-sentence investigation report, but we can do the scheduling at a later time. Is there anything else, Mr. Anderson?
No.
Mr. Schroffesy?
No, sir.
All right. Thank you, everyone. Court is adjourned.
Okay, I need everyone but the foreperson to please have a seat. Okay, and Madam Foreperson, I understand that the jury has reached a verdict. Is that correct? Okay, could you please hand that to the bailiff, and you can have a seat. State of Indiana versus Elizabeth Joanne Fox-Doerr, verdict. We, the jury, find the defendant guilty of count 1 as charged in the information signed and dated this date. Verdict, count 2. We, the jury, find the defendant guilty of count 2 as charged in the information signed and dated this date.
She did it, right? Guilty, both counts. Jury found it. She'll be sentenced at a later date. So once again, there she is, Becky Fox-Doerr, guilty of murder, guilty of conspiracy to commit murder of her husband, Robert, all because she found somebody else.
In the Superior Court of the State of California, in and for the County of San Diego, the people of the State of California, plaintiff versus Ali Nasser Abulaban, defendant, case number SCD 292181, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Rayburn Cardenas.
Silence. Nothing.
Of Rayburn Cardenas Baron in violation of Penal Code Section 187, Parent A, as charged in count 2. Oh, it is. Okay. In count 2 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant, Ali Nasser Abulaban, intentionally and personally discharged a firearm, to wit, a handgun, and proximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant, Ali Nasser Abulaban, that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, parent A, parent 3, to be true. Dated May 29th, 2024, jury 4-person. Same title, same cause, verdict. We, the jury in the above entitled cause, find the defendant, Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Anna Abulaban in violation of Penal Code Section 187, parent A, as charged in count 1 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant, Ali Nasser Abulaban, intentionally and personally discharged a firearm, to wit, a handgun, and proximately caused great bodily injury and death to a person within the meaning of Penal Code Section 12022.53, parent D, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant, Ali Nasser Abulaban, that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, parent A, parent 3, to be true. Dated May 28th, 2024, jury 4-person. Ladies and gentlemen of the jury, was this and is this your verdict as I have just read to you? Yes. Ladies and gentlemen of the jury, I will ask you individually, was this and is this your verdict as I have just read? Please answer yes or no to that question. Juror number 1, was this and is this your verdict? Juror number 2, same question. Juror number 3, same question. Juror number 4, same question. Juror number 5, same question. Juror number 6, same question. Juror number 7, same question. Juror number 8, same question. Juror number 9, same question. Juror number 10, same question. Juror number 11, same question. And juror number 12, same question. Your Honor, all answer in the affirmative.
Charlie, record the verdict. Ladies and gentlemen, you have now completed your jury service on this case.
All right, the court's going to next just make a reference that there is a courtroom conduct order in effect in this proceeding to remain in effect. So I appreciate everyone complying with that order, as most of you have done throughout the proceedings in this case. At this time, then, the first matter I'd like to take up is to do a roll call of the jury for the record. So, Madam Clerk, if you could please conduct a roll call of our jury to make sure they're all present and properly seated at this time.
Juror number 1, red card number 27. Juror number 2, red card number 219. Juror number 4, red card number 631. Juror number 5, red card number 653. Juror number 7, red card number 752. Juror number 8, red card 1680. Juror number 9, red card number 823. Juror number 10, red card 1358. Juror number 11, red card 1365. Juror number 12, red card 716. Juror number 14, red card 997. And juror number 15, red card 1078.
All right. Thank you, Madam Clerk, for conducting the roll call. All right, at this time, I'm next going to inquire from the jury 4-person. Has the jury reached a verdict? All right, thank you. Mr. Bailiff, if you would please retrieve the verdict from the jury 4-person. Thank you. All right, the court has reviewed the verdict form. I'll note that all counts have been properly marked, as well as the verdict form's been properly dated and signed by the foreperson. The next step then is Mr. Daybell, if you and counsel would please rise. I'm going to have the clerk read the verdict.
In the District Court of the 7th Judicial District of the State of Idaho in and for the County of Fremont. State of Idaho Plaintiff versus Chad Guy Daybell Defendant, case number CR 22211623. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Guilty. Question number 2. In regards to count 2 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tylee Ryan? Guilty. Question number 3. In regards to count 3 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson-Bolanos and grand theft by deception? Guilty. Question number 4. In regards to count 4 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Joshua Jackson-Bolanos? Guilty. Question number 5. In regards to count 5 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tamara Tammy Daybell? Guilty. Question number 6. In regards to count 6 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tamara Tammy Daybell? Guilty. Question number 7. In regards to count 7 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Question number 8. In regards to count 8 of the amended indictment, in regards to count 9 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Dated this 30th day of May, 2024, and signed by the presiding juror.
All right, Madam Clerk, thank you for reading the verdict. At this time, I'm just going to collectively ask the jurors, all of you, is this in fact your unanimous verdict on each of those counts? Very well. At this time, I'm going to inquire if the parties wish to have the jury polled. Does the state wish to have the jury polled?
No, Your Honor. Thank you.
Does the defense, Mr. Pryor, wish to have the jury polled?
No, Your Honor. Thank you.
As the 12 deliberating jurors are back in the jury box. In addition, we have our alternates seated in the jury box to prevent them from appearing on camera. So those are seats 4 and 11. In addition, seats 3 and 13 are empty as those jurors have been excused. Madam Foreperson, would you please rise? Madam Foreperson, has the jury reached a verdict?
They have, sir.
And is that verdict unanimous?
Yes.
Ma'am, I'm going to read to you each count. Please give me the jury's unanimous response. 1, how do you find as to count 1, endangering the welfare of a child?
Guilty.
2, how do you find as to count 2, murder?
Not guilty.
3, how do you find as to the charge of aggravated manslaughter?
Guilty.
And you did not answer question 4?
No, sir.
At this time, thank you, Madam Foreperson, you can be seated. At this time, I'm going to poll the jury. Members of the jury, you've heard the verdict as read by your foreperson. At this point, I'm going to ask each juror by number, except the 2 alternates, to respond yes if the verdict read by the foreperson is your verdict, no if the verdict read by the foreperson is not your verdict. Juror number 2.
Yes.
Juror number 3 is empty. Juror number 4 is alternate. Juror number 5.
Yes.
Juror number 6.
Yes.
Juror number 7.
Yes.
Juror number 8.
Yes.
Juror number 9.
Yes.
Juror number 10.
Yes.
Juror number 11 is an alternate. Juror number 12. Yes. Juror number 13 has been excused. Juror number 14.
Yes.
Juror number 15.
Yes.
Juror number 16. Is counsel satisfied that the verdict is unanimous?
Yes.
At this time, I would ask the clerk to record and note in the minutes that the verdict is unanimous. Ladies and gentlemen of the jury, the function you have performed is one of the most important civic duties you can ever be called upon to fulfill. With the return of your verdict, your service in this case is complete. Upon your discharge, you are not required, except upon court order, to discuss your deliberations or verdict with anyone. Additionally, no attorney or party or any person acting on their behalf is permitted under our rules of court to examine you or question you or even to discuss with you your verdict or your deliberations or your role in this matter. In some states, judges are actually able to stay afterwards and speak to the jurors about the experience. In New Jersey, judges and attorneys are specifically prohibited from doing that. If anyone approaches you associated with the case, the attorneys or the parties, please notify me immediately. It's possible you may be contacted by others, including members of the media. As you know, obviously we had media coverage in this trial. It will be up to each of you to decide whether or not to speak to those persons or entities about your service as a juror. If you agree to be interviewed, you may discuss whatever you want in whatever manner you deem appropriate. However, I'd ask you to keep these things in mind. The key to your function as jurors has been the free discussion amongst yourselves during deliberations, and the privacy of those deliberations is essential to the continuation of the fair administration of justice. All jurors have the prerogative to keep confidential their communications with their fellow jurors during deliberations. In fact, it is in the public interest that there be the utmost freedom of discussion in the jury room and that each of you be permitted to express your views without concern for public reaction or criticism. Under no circumstances should you make a statement to the media or anyone else that you would not be willing to repeat under oath in court in the presence of your fellow jurors. But on a personal note, I want to thank you for your service. I know we told you in the beginning that it's a civic duty, but this case was a long case. It was difficult scheduling issues, and it was a difficult case with a lot of emotion. I told you we had the best justice system in the world, and one of the reasons, probably the principal reason, is because our Constitution guarantees a right to a trial by jury, and we can't do this without you. It's truly remarkable witnessing this reality and your participation in it. It's not only been my pleasure to have you here, it's been my privilege to have you here. I'm going to give you one final instruction, and I'm sure the attorneys join in that, by the way, our thanks and our appreciation for your attention and also how you've gotten along as a group. But I'm going to give you one final instruction, and that is the Sheriff's Department is going to escort you out that door, out a separate private entrance to the courthouse. I don't want to risk that somebody who's upset one way or the other comes up to you. They're going to make sure there's plenty of officers taken to your cars. So if you want to exchange some telephone numbers or something like that, if you become friends, I ask you to do that quickly because I would really appreciate that you get in your vehicles and you go home and get out of here in the event there's any reaction by anyone. So again, thank you so much for your service. Just hand Corporal Bennett your jury pass on the way out and the verdict sheet. And been my pleasure, ladies and gentlemen. Thank you so much.
I think ask everybody in the gallery to please remain in the courtroom until the jurors have left.
Folks, we have breaking news in another case that Court TV has been covering, the missing stepdaughter trial in North Carolina. The jury has now reached a verdict.
As foreperson of the jury, you have returned as the unanimous verdict of the jury in case number 22 CR 366223 that you find the defendant, Christopher James Palmer, guilty of failure to report disappearance of a child to law enforcement. Was this your verdict?
Yes.
Ladies and gentlemen, jury, please stand. Your foreperson has reported to the court you found the defendant, Christopher James Palmer, in 22 CR 366223, guilty of failure to report disappearance of a child to law enforcement. Was this your verdict? So say all of you? Yes. You may be seated.
As you heard, the jury found Christopher Palmer guilty of failing to report 11-year-old Madalena Kojikari missing. Now, she was last seen in December of 2022. Palmer took the stand in his own defense, saying he didn't harm his stepdaughter and does not know where she is, but he was not charged with those crimes. He was only charged with not reporting her missing. It took 3 weeks for he and his wife to report her missing. Diana Kojikari, the child's mother, pleaded guilty earlier this month on the same charge. She was sentenced with time served, which was she was in jail about 17 months. And Madalena still has not been found.
Ready to go? Ready for the jury?
All right, Officer Elam, whenever you're ready, if they're ready.
All rise.
All right, let's have a seat. Good afternoon to you all. Madam Foreperson, has the jury reached a verdict in this case?
No, Your Honor.
Do you feel like that it is likely that the jury on continued deliberations will reach a verdict?
No, sir.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Is there a disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls?
No, I'm sorry. It is not. That is not the case for the highest offense.
Okay. Does the jury agree on the highest level of offense that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the jury has found the defendant not guilty of first-degree murder?
Yes.
Okay. May I borrow the charge book for a minute so I can look at the verdict form? If you need it back to look at it, just tell me. Has the jury considered the second level of the offense attempted first-degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, sir. There is an agreement.
Has the jury considered the level of offense second-degree murder?
Yes, sir.
Is there an agreement that the defendant is not guilty as to second-degree murder?
Not guilty.
I have not asked you specifically, but are all of these agreements unanimous as to these levels of charges?
Yes, Your Honor.
Okay.
We have one shaking his head.
Beg your pardon?
We have one shaking his head.
I'm sorry. My question, and I'll come back in. My question was, is it unanimous that the defendant is not guilty of second-degree murder? And I'm going, since there was it's my question. Is there an agreement on that level of charge?
Agreement with who?
Not.
Oh, I'd say not guilty on that one.
Sir, ma'am. Not guilty as to second-degree murder. Is that correct?
Correct.
Okay. That cleared that up, General?
Yes.
Has the jury considered the next level of charge, attempted second-degree murder?
Yes, sir.
Do you all find the defendant not guilty of attempted second-degree murder?
Yes, sir.
Each of you? Ma'am? Okay, I'm looking at you because I want to see, and if you disagree, just let me know, okay? Now, let's go back. We did not do this as a first-degree murder charge that I'm told you found him not guilty of. Is that correct? Okay, I see head nodding affirmatively. And attempted first-degree murder. Is that correct as well? Okay. Has the jury considered the charge of voluntary manslaughter?
Yes, sir.
Is there an agreement, or has the jury found the defendant not guilty of voluntary manslaughter?
There was no agreement.
No agreement? Is that the level of the offense at which there is disagreement?
Yes, sir.
Is that correct, ma'am? All right. Would the state like the jury polled as to the first 4 level of charges?
No, Your Honor.
Or as to the level on which there's a disagreement? I think since we don't have a verdict, there's no reason to poll the jury as to that level. You agree, Mr. Taylor?
I agree, Judge.
I'm going to ask each of you this question. You just tell me, would further deliberations be of any value?
No, sir.
No, sir.
Okay. Do you all believe that the jury is hopelessly deadlocked with respect to the charge of voluntary manslaughter? I see everybody nodding their head yes. The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter a charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court believes that the jury is hopelessly deadlocked with respect to the next level of charge, that is voluntary manslaughter. Is there any reason that the court should not declare mistrial at this time, General?
No, Your Honor.
Mr. Taylor?
No, Your Honor.
Court will enter and declare mistrial with respect to the charge of voluntary manslaughter. I want to say something to you. The jury, having completed the work as required by law and by this court, is discharged and excused with the sincere gratitude of the court. Judge Parham and Mrs. McMahon have asked me to tell you that you are excused from further service in this term. You do not have to report in August. You've done more than a share. I understand the personal sacrifices that each of you have made to be here every day on time, and specifically the sacrifices over the 11 hours plus in 2 days that you have spent attempting to reach a decision in this case. I thank you for your work, for your time, for your dedication to this case, because that is dedication to our system. That's dedication to our jury system and our effort to provide a fair trial for anyone who's accused of a criminal offense. Don't be frustrated or discouraged because you weren't able to resolve the case fully. It happens. You did exactly what the court and the attorneys asked you to do and what the law requires you to do, and that is to consider a matter on which reasonable minds can obviously have differing opinions. Okay, you did exactly what we asked you to do. You're released from the previous restrictions of discussing the case or from viewing social media posts or the video of the trial. And I bet every one of you want to go home and rewatch that right now. You can talk with anyone that you please, but you're under no obligation to talk to anyone whatsoever. I think some of the media have provided you with their contact information rather than besieging you once you leave the courthouse. That is not to say that you may not be met with questions and cameras. It is your decision whether you want to talk to anybody about any aspect of this thing. If you watch any portions of the trial later on or start reading social media posts, you're going to find out that there was some information that the court, and when I say the court, I mean me, that I excluded from the trial of this case because I did not think that it passed the requirements of the rules of evidence. It was my call. I stand behind my decision on that because I thought that's what the law required me to do. But you'll be surprised when you do see that. It has been a distinct honor and a privilege to serve with you, each and every one of you in this case. I'm proud of you, and I wish you the best. You're released. Officer Elam will help you get your electronics and any personal things you have there, and once you get those, you are free to leave. I think, have you already handed out excuses, or you have those? We got those to give you. Maybe.
She's going to give each of
Yeah,
them
Emily
a
can.
badge.
Yeah, okay. Can follow them in and hand out those. Thank you very much for your service. Once again, let's rise for the jury. All rise.
The jury, my understanding is you have reached a verdict. All right, do you have the verdict form? All right, you pass that to the bailiff. Verdict form appears to be in order. I'll have the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action. State of Florida versus Wade Wilson. Case number 19 CF 0568. Verdict. We, the jury, finds as follow as to the defendant in this case. Count 1, first-degree murder, Christine Melton. The defendant is guilty of first-degree murder. Count 2, grand theft motor vehicle. The defendant is guilty of grand theft motor vehicle. Count 3, battery. The defendant is guilty of battery. Count 4, first-degree murder, Diane Ruiz. The defendant is guilty of first-degree murder. Count 5, burglary of dwelling. The defendant is guilty of burglary of a dwelling. Count 6, first-degree petty theft. The defendant is guilty of first-degree petty theft. Dated 6/12/24, so say we all, four-person.
Ready? All right. Good evening. Has the jury reached a verdict? Okay, if you'll hand it to my bailiff. Thank you. All right. State of Georgia versus Miles Bryant. Indictment number 24B00156-4, count 1, malice murder,
We, the jury, find the defendant guilty. Count 2, felony murder. We, the jury, find the defendant guilty. Count 3, kidnapping. We, the jury, find the defendant guilty. Count 4, criminal attempt to commit rape. We, the jury, find the defendant not guilty. Count 5, false report of a crime. We, the jury, find the defendant guilty. Signed June 12th, 2024 by the foreperson.
For the record, what's your name?
Katie Brower, CV.
Okay. And has the jury reached a verdict?
Yes.
Would you give the verdict form to my marshal, please? Will the defendant and her attorney please stand? The clerk will now read the verdict out loud.
District Court, Clark County, Nevada, State of Nevada versus Cameron Bordeaux, case number C19340404-1, Department 2. The verdict reads as follows. We, the jury, in the above entitled case of the defendant, Pamela Bordeaux, as follows. Count 1, murder with use of a deadly weapon, guilty of first-degree murder with a deadly weapon, dated this 20th day of June. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes. Do either party desire to have the jury closed? Okay. The clerk will now record the verdict in the minutes of the court. You may be seated. Ladies and gentlemen, as we explained during the jury selection process, there are actually 2 phases to this proceeding. There's a sentencing hearing as you come back on the first-degree murder portion. So at this point, we're going to take a break to get ready for that portion, but it is going to start today, so I'm going to have you guys take an hour break. During this time, you're still not allowed to talk to anyone about the deliberation or anything until you've completed the final portion. We also do need to get the alternates back, so that's why we need that hour to get ready. So during this recess, you are admonished not to talk, converse amongst yourselves with everyone else on any subject connected to the trial, or read, watch, listen, and report or commentary on the trial of any person connected to this case by any medium of information, including without limitation, newspaper, television, internet, and radio, or form or express any opinion on any subject connected to the trial of the case is submitted to you for sentencing. So we will have you guys back here at 12:25. Please rise for the jury.
And with that, we are hearing that this jury decided that Pam Bordeaux is guilty of first-degree murder with the use of a deadly weapon. No reaction from Pam Bordeaux in hearing this very, for her life, dissatisfactory decision from the jury. For the family of Sean Babbitt, surely justice for their relative in this shooting that she said was self-defense there inside of her home. She's now facing up to life in prison without the possibility of parole. And you heard there that the jury is actually going to be coming back for the sentencing hearing in about an hour. Let me bring in legal correspondent Kelly Craft is with us, trial attorney Miguel Custodio. Kelly, your reaction?
Well, I did think that they would probably come back with guilty the way this went down. I know a lot of people like to say, well, she was a police officer. She gets a lot of credit, automatic credibility. I don't know if that's still the case in this day and age. I think the way the state presented this case with that hook of child custody changing, the changes wanted by this defendant. If that wasn't there, I think that maybe this could have gone the other way, but when the prosecutor was able to tie that in there and say, after 156 visits, nothing happened during those 156 visits, and then all of a sudden, he wants more time with his son, and she doesn't want that, and so she kills him.
Miguel, no reaction from this defendant.
Yeah, and I'm surprised, to be honest, because maybe on the stand, you know, she seems collected, but once you hear that guilty verdict, I thought we were going to get reaction, but she's not. And so it's very interesting, right? Because I really thought that this was going to come down the way it did, right? And I think the motive, like Kelly was saying, is there. There's a motive. when you have 10 shots, it's really just really hard to say that it was in self-defense. Maybe 1, 2, 3, 4. She's law enforcement. She has more experience than your normal person handling a gun. And so I think it went the way that everything was looking like it was going to go.
2 hours and 41 minutes is all it took for this jury to make a decision, and they did not come back with the lesser included of second-degree murder, voluntary manslaughter, which would have carried sentences of up to 10 years if it was voluntary manslaughter, up to 25 years if it was second-degree murder, but she is now facing up to life in prison without the possibility of parole. We are going to squeeze in a break. That penalty phase in the Bordeaux case begins in an hour.
Welcome back. All this week, we've been bringing you our coverage of California versus Jade Jenks. She is charged with first-degree murder for the death of her ex-stepfather, Tom Merriman, who police say was found in a driveway underneath several boxes of trash. The prosecution says Jenks felt betrayed and plotted to kill him after finding nude photos of herself on his computer. They believe that she drugged and strangled him to death after she found these photos. The trial lasted 10 days. After just 5 hours and 42 minutes of deliberations, the jury reached a verdict.
Jury number 9, foreperson?
Yes, I am, Your Honor.
First jury reached a verdict.
We have, Your Honor.
All right, would you please hand that to my bailiff? All right, Madam Clerk, would you please read the verdict?
Superior Court of the State of California for the County of San Diego, the people of the State of California plaintiff versus Jade Sasha Jenks, defendant. Case number SCN 420772. Verdict, count 1, first-degree murder. We, the jury, in the above entitled cause, find the defendant, Jade Sasha Jenks, guilty of the crime of murder in violation of Penal Code Section 187, subsection A, a felony, as charged in count 1 of the amended information, and fix the degree thereof as murder in the first degree. Dated today's date, signed the foreperson. Ladies and gentlemen of the jury, was this and is this your verdict as read?
Yes.
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 All right, does either side wish to have the jury polled?
No, Your Honor. Yes, Your Honor.
All right, Madam Clerk, would you please poll the jury?
Ladies and gentlemen of the jury, please answer with a yes or no, answer only, as to count 1, first-degree murder. Was this and is this your verdict as read? Juror number 1.
Yes.
Number 2.
Yes.
Number 3.
Yes.
Number 4.
Yes.
Number 5.
Yes.
Number 6.
Yes.
Number 7.
Yes.
Number 8.
Yes.
Number 9.
Yes.
Number 10.
Yes.
Number 11.
Yes.
Number 12.
Yes.
Your Honor, I record 12 affirmative responses.
All right, Madam Clerk, please record the verdict.
So recorded, Your Honor.
There you have it.
Mr. and Ms. Murray, you'll stand to receive the verdict of the jury. Ms. Farmer, as to defendant Karen W. Murray in case number 47002A, in count 1 for the offense of first-degree murder and commission of a felony, which is aggravated neglect of a vulnerable adult, how did you find the defendant Karen Murray guilty or not guilty? No, you can just say if you found her guilty or not guilty.
Guilty.
Of the indicted offense. All right. As to Mr. Michael Murray, in case number 47002B, did you find the defendant guilty or not guilty of first-degree murder during the commission of a felony, aggravated neglect of a vulnerable adult?
Guilty, Your Honor.
All right. As to count 1 for Ms. Karen Murray, so say you all. All jurors agree on the verdict. All have nodded in assent. As to Mr. Michael Murray in count 1, so say you all as to the announced verdict. All jurors nod in assent. All right. Ms. Farmer is foreperson of the jury. In count 2 for Karen Murray, did the jury find the defendant guilty or not guilty of aggravated neglect of a vulnerable adult with injury?
Guilty.
And as to count 2 for Michael Murray, did the jury find the defendant guilty or not guilty of aggravated neglect of a vulnerable adult with injury?
Guilty.
As to Karen Murray, with that verdict announced, so say you all. All jurors not in assent. And as to defendant Michael Murray, so say you all. All jurors not in assent. As to count 3 for defendant Karen Murray in case number 47002A to the offense of aggravated neglect of a vulnerable adult with physical harm, did the jury find the defendant guilty or not guilty of that indicted offense?
Guilty.
And as to count 3, defendant Michael Murray, how did the jury find the defendant guilty or not guilty of aggravated neglect of a vulnerable adult with physical harm?
Guilty.
As to defendant Karen Murray, to the announced verdict, so say you all. All jurors nod in agreement. Yes, Mrs. Beasley? Yes. And as to defendant Michael Murray, how do all defendants nod in assent or disagreement? All jurors agree. All right, all jurors have nodded in assent. All right, if you'll be seated. Thank you. You may be seated, Mr. and Miss Murray. All right, ladies and gentlemen, I cannot thank you enough on behalf of myself, the court staff, and the court clerk's office, Ms. Downs and her staff, as well as the attorneys involved, for sacrificing the week to do your civic duty and sit as a juror in this case. I know it's been a difficult and trying case, and I will remind you that you do not have to discuss your verdict with anyone. If you do elect to discuss your verdict with anyone, I would ask you to be respectful and mindful of your other jurors' thoughts and the conduct of any juror during the deliberation who may not wish their comments or decisions discussed by any other juror. Discretion is the better part of valor in these types of things. If you wish to talk to any of the attorneys, sometimes attorneys will call jurors and say, I'd like some guidance on what we could have done differently, what you found important, what you found not so important or significant, and you are the best judges to give them that kind of information, okay? And it's extremely helpful as far as your commentary if any of the attorneys were to call you, okay? I would like to speak with you just briefly before you're excused for the afternoon. I am going to release all of you for future jury service this term. This will be the only trial you will have to sit on. You will not have to call back in for any other trial. Now, in the future, you may get one of those brown cards that says you've been summoned for jury service again, but you should be clear for, what is it, Tammy, 2 years? 2 years. You should be clear for 2 years. I've spoken with the other judges who may have trials between now and when your jury service would end in early September, and we all feel secure that we have enough jurors, and this has taken enough pound of flesh, so to speak, from your day-to-day lives and for this type of difficult case. So I appreciate the emotional investment, the investment of your time, and the consideration and attention that you gave to this case. I cannot thank you enough. I'm going to speak with you briefly. I'll be back there. If you'll wait in the jury room just a moment, I'm going to address the attorneys, and I'll be right there. It won't take me just a couple of minutes. If you'll...
Please rise for the jury. Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please. Thank you. Be seated. Court is still in session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m., Your Honor? And I would appear for my client.
All right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to leave for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates, so.
What about the 19th at 9? Is that whole week?
No, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so the court knows, Ms. Little and I are not available on the 22nd. We had a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not appear.
Okay. So you and your client will be here in person, Ms. Giannetti?
Yes.
All right. All right. Thank you. We'll see you then.
Welcome back. We are following breaking news out of Michigan, where a partial verdict has been returned in the case against Michael Jackson-Bolanos for the death of Samantha Wall. We are going to go into the courtroom now. The judge has talked to the parties about a note that she received. Keep in mind, this jury said multiple times they were hung on this case, and another alternate juror was brought in. There was some movement. They returned today for the last day of deliberations. Let's go in.
The jury was unable to reach a verdict as to counts 1 and 3, and the people will have to make decisions as to whether they're going to retry those counts. And we're going to set a pretrial for let's see when next week. 2 weeks. How much time?
Sooner.
Next week. Look at my calendar for next week.
And Judge, I'd ask for at least a week because
So
25th.
Thursday the 25th at noon?
Yeah.
Does that work?
That's fine, Judge.
Okay. So Thursday the 25th at noon, we'll have a pretrial If there are any motions you plan to make, please file that as soon as possible, the written motions, and we will address everything then and set a new trial date if it's going to be retried.
And Judge, I may have missed this, but is the court going to formally enter an order declaring a mistrial on those?
Yes,
on those
I am
counts?
declaring mistrial as to counts 1 and 3, and I have the order in front of you.
Thank you, Judge.
And I'll acquittal on count 2 only, and PSI until next week, and I may just return to PSI until I figure that out next week. That concludes.
All right, there you have it. After 5 days of deliberation, they did come back on some charge 2. Let's bring in criminal defense attorney through these because it was pretty quick there inside of the courtroom, but locked on. Premeditated murder, though, they found him not on as him guilty of this jury.
It is a but that is defense, a mistrial or a hung jury. Decide we retry the case, make 18 charges against the defendant.
Heard that they're going to set up or premeditated murder. Sounds like they set out to. Her door was unlocked and admittedly took the stand and said he was breaking of not believing that he actually believing one thing or another. So Rob, if you're the prosecution, do you go back to and talk about perhaps a deal on were clearly some jurors who did not want to give in on him being not guilty of felony murder?
If I was the prosecutor, I definitely would engage in conversations with the defense, but that would be after I found out what the split was. For instance, if it was a split for 10 for guilty, 2 for not guilty, I may not engage in conversations and we would just try it again. But if the majority of the jurors voted not guilty, then that would be something I'd have to think long and hard about if I was going to retry that case.
Yeah, we've had big questions about that here on Court TV, most notably with the Karen Reed trial, where there was a mistrial, and then a big question of, did they have a partial verdict there in the deliberation room? The jury wasn't officially polled by the judge, so not sure if they're going to be officially polled there in Detroit, Michigan, a different jurisdiction, perhaps a different way that the judge handles it, but we will see, and of course, keep everyone updated on those developments out of that courtroom and case.
Jury entering.
Please be seated. Has the jury selected a foreperson?
Yes.
Juror number 7, are you the foreperson?
Yes, ma'am.
Has the jury reached a verdict?
We have.
Please fold the verdict in half, hand it to the deputy, who will give it to me. Madam Clerk, please publish the verdict.
In the Circuit Court of the 15th Judicial Circuit Criminal Division, and in 4 Palm Beach County, Florida, case number 19 CF 7582, Division U, State of Florida versus Marsha Thompson. Verdict, not guilty.
Deputy, stop it! Stop it!
You ready to bring in the jury?
Yes, sir.
All right, bring them in. All right, you all can have a seat. Members of the jury, I understand you have a verdict, and we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? We need to check it, make sure it's in proper form. All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit, NN4, Manatee County, Florida, the State of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl, foreperson.
Would either side like the jury polled? State?
No.
Defense?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty.
Ms. Wolf, are you the jury foreperson?
Yes, sir.
Has the jury reached a verdict?
Yes, we have.
I'd ask that you hand that verdict to the bailiff, please. Court is going to ask the clerk to read the verdict.
We, the jury, find the defendant guilty of felony murder, aggravated battery with the intent to cause bodily harm as set forth in count 1 of the information.
Is there any request to poll the jury?
No, Your Honor.
What say you, Madam Forelady, as to indictment number 2183CR00153 on offense number 001, wherein the defendant, Christine Ricci, is charged with the crime of murder. Is she guilty or not guilty?
Guilty.
Guilty of what?
Murder in the second degree.
Thank you. As to offense number 002, wherein the defendant, Christine Ricci, is charged with the crime of assault and battery by means of a dangerous weapon, is she guilty or not guilty?
Guilty.
Your Honor, may the verdict be affirmed.
Yes, they may.
Thank you. Members of the jury, hearken to your verdict as the court has so recorded it. You, upon your oath, do say that the defendant, Christine Ricci, is guilty of murder in the second degree on indictment number 2183CR00153, offense number 001. So say you, Madam Forelady.
Guilty.
So say you, all members of the jury.
Guilty.
You further, upon your oath, do say that the defendant, Christine Ricci, is guilty on indictment number 2183CR00153 on offense number 002 on the charge of assault and battery by means of a dangerous weapon. So say you, Madam Forelady.
Guilty.
So say you, all members of the jury.
Guilty.
Thank you. Your Honor, the verdict has been recorded and affirmed.
Jurors, you may be seated.
Welcome back to Court TV Live. I'm Michael Ayala. We're going to begin with breaking news out of Wisconsin. The jury has reached a verdict in the triple murder over $600 trial of Nia Tao. So let's get you out to court.
Has the jury reached a verdict? Can you give it to Terry and she'll hand it to me?
State of Wisconsin versus Nia Tao, Lacrosse County case number 21CF582. Verdict, count 1. We the jury find Nia Tao guilty as to count 1 as charged in the information. Signed by the foreperson. Count 2. We the jury find Nia Tao guilty as to count 2 as charged in the information. Signed by the foreperson. Count 3. We, the jury, find Nia Tao guilty as to count 3 as charged in the information. Signed by the foreperson. Count 4. We, the jury, find Nia Tao guilty as to count 4 as charged in the information. Signed by the foreperson. Dated this 13th day of August, 2024.
Now, ladies and gentlemen of the jury, I'm going to ask you if that's your verdict as to each count. If you can all say yes, then we'll go to whether we should poll the jury. Members of the jury, as to count 1, is that your verdict?
Yes.
Members of the jury, as to count 2, is that your verdict?
Yes.
Members of the jury, as to count 3, is that your verdict?
Yes.
Members of the jury, as to count 4, is that your verdict?
Yes.
Does the state wish to poll the jury?
Yes, Your Honor.
And Mr. Nelson?
I think it's required.
I'm not sure. But anyways, so what I'm going to do is start with 1 up here and then move. I'll just go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. That makes sense. Everybody understands that? You're all nodding yes. Jury number 1, as to count 1, is that your verdict? Jury number 2, as to count 1, is that your verdict? Jury number 3, as to count 1, is that your verdict? Jury number 4, as to count 1, is that your verdict? Jury number 5, as to count 1, is that your verdict?
Yes.
Juror number 6 is to count 1, is that your verdict? Juror number 7 is to count 1, is that your verdict? Juror number 8 is to count 1, is that your verdict? Juror number 9 is to count 1, is that your verdict? Juror number 10 as to count 1, is that your verdict? Juror number 11 is to count 1, is that your verdict? Juror number 12 is to count 1, is that your verdict? Juror number 1 is to count 2, is that your verdict? Juror number 2 as to count 2, is that your verdict? Juror number 3 is to count 2, is that your verdict? Juror number 4 is to count 2, is that your verdict? Juror number 5 is to count 2, is that your verdict?
Yes.
Juror number 6 is to count 2, is that your verdict? Juror number 7 is to count 2, is that your verdict? Juror number 7 is to count 2, is that your verdict?
Yes.
Juror number 7, or excuse me, juror number 8, did I say 7? Number 8, number 9 is to count 2, is that your verdict? Juror number 10 as to count 2 is your verdict. Juror number 11 as to count 2, is that your verdict? Juror number 12 is to count 2, is that your verdict? Juror number 1 is to count 3, is that your verdict? Juror number 2, is that you, as to count 3, is that your verdict? Juror number 3, as to count 3, is that your verdict? Juror number 4, as to count 3, is that your verdict? Juror number 5, as to count 3, is that your verdict?
Yes.
Juror number 6, as to count 3, is that your verdict? Juror number 7, as to count 3, is that your verdict? Juror number 8, as to count 3, is that your verdict? Juror number 9, as to count 3, is your verdict? Juror number 10, as to count 3, is that your verdict? Juror number 11, as to count 3, is that your verdict? Juror number 12, as to count 3, is that your verdict? Now, juror number 1, as to count 4, is that your verdict? Juror number 2, as to count 4, is that your verdict? Juror number 3, as to count 4, is that your verdict? Juror number 4, as to count 4, is that your verdict? Juror number 5, as to count 4, is that your verdict?
All right, so Neotow on the retrial found guilty of all charges by that jury in Wisconsin.
All right. Verdict Form 1 reflects that we, the jury, find Alec Ray Jones guilty of the crime of murder in the first degree. Is this your verdict? Yes. I'm just going to ask you individually, starting in the back row at the left, if this is your verdict. And I'll just start with you, sir. You, sir? Yes. You, ma'am? Yes. You, ma'am? Yes. Sir? Yes. All right. Thank you, ladies and gentlemen.
Can you please hand the verdict to the bailiff, please? I'll have the clerk read the verdict.
Verdict as to count 1. We, the jury, find as to count 1 of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number 1, is this your verdict? Juror number 2, is this your verdict? Yes. Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict? Yes. Juror number 5, is this your verdict? Yes. Juror number 6, is this your verdict?
Yes.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay? There you go. Also, here's the last one. Oh wait, I don't think I dated that. Let me do that one back. Ms. Lawrence, the jury has found you guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense. I assume that sentencing will be at a later date, is that correct?
That's correct, Judge.
Are you requesting a pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case. I'll put it all the way to the November docket, although I expect us to be sentenced long before that. I'm just putting us far enough away to get everything done. So when we get the PSI done, then please contact my office. We'll set a sentencing. Ms. Lawrence, you're going to be held in custody of the Marion County Jail without bond until that time.
Objection.
All right, folks, we're going to step aside with our coverage from Las Vegas to turn to Tennessee, where our understanding is the jury has let the court know that they have reached a verdict. It looks like about 11 hours and 49 minutes or so it took them to come up with this verdict. I do hear some audio coming from the courtroom, so let's go out to that courtroom in Tennessee.
Count 1, premeditated first-degree murder of Jennifer Paxton. We, the jury, find the defendant Shannon Finnegan guilty of criminally negligent homicide. Verdict form for count 2, first-degree felony murder of Jennifer Paxton during the perpetration of attempt to perpetrate aggravated rape. We, the jury, find the defendant Shannon Finnegan guilty of first-degree felony murder during the perpetration or attempt to perpetrate for aggravated rape. Next, count 3. We, the jury, find the defendant, Sean Shannon Finnegan, guilty of first-degree felony murder during the perpetration or attempt to perpetrate aggravated kidnapping. Count 4. We, the jury, find the defendant, Sean Shannon Finnegan, guilty of attempted aggravated rape. Count 5. We, the jury, find the defendant, Sean Shannon Finnegan, not guilty of the case of aggravated rape with bodily injury to Jennifer Paxton. Count 5, aggravated rape, aiding or abetting with one or more persons. We, the jury, find the defendant, Sean Shannon Finnegan, guilty of aggravated rape. Count 7, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of aggravated kidnapping. Count 8, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of especially aggravated kidnapping. Count 9, we, the jury, find the defendant, Sean Shannon Finnegan, not guilty of conspiracy to commit premeditated first-degree murder. Count 10, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of conspiracy to commit aggravated rape. Count 11, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of conspiracy to commit aggravated kidnapping. We, the jury, find the defendant, count 12, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of abuse of a corpse. And finally, count 13, regarding tampering evidence, we, the jury, find the defendant, Sean Shannon Finnegan, guilty of tampering with evidence. Thank you. You can have a seat, please. So, ladies and gentlemen of the jury, that means we've still got some more work to do. But first thing I have to do is I have to poll the jury. And so don't worry about your prior numbers. I'm just going to go down the line and refer to you by number to make sure everybody agrees with these verdicts that I've just read in there. Juror number 1 on the back row, is that your verdict, sir?
Yes, sir.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
Juror number 7?
Yes.
Juror number 8?
Yes.
Juror number 9?
Yes.
Juror number 10?
Yes.
Juror number 11?
Yes.
And juror number 12?
Yes.
Okay, the clerk will now read the verdict form out loud. The defendant and his attorneys will stand for the reading of the verdict.
District Court, Clark County, Nevada, State of Nevada, Plaintiff versus Robert Tellis, Defendant, case number C-368935, Department number 12, verdict. We, the jury in the above entitled case, find the defendant, Robert Tellis, as follows. Murder with use of a deadly weapon, victim 60 years of age or older. Guilty of first-degree murder with use of a deadly weapon, victim 60 years of age or older. Special verdict. The jury unanimously finds the murder willful, deliberate, and premeditated. The jury unanimously finds the murder was committed by means of lying in wait. The jury unanimously finds the murder was committed by means of elder abuse. Guilty of first-degree murder with use of a deadly weapon, special verdict. The jury unanimously finds the murder willful, deliberate, premeditated. Do you want me to finish this?
I'm just having the attorneys approach for just a moment.
Thank you, Judge.
Guilty of all of it, first-degree murder. Philip and Marie still with me. Philip, your response? I don't think this is unexpected based on the evidence.
No, not only did they find the first degree true, but they found the special circumstances of lying in wait, elder abuse, and that it was willful, deliberate, and premeditated. And I do believe that under Nevada law, it is a mandatory life sentence. I think for this jury, he came off as a moral menace, sort of like the decayed devil, the shriveled soul with manipulative morality on the stand. And now he has heard
Dated
his
this
jury's
28th
speech.
day of August 2024, signed by foreperson, juror number 2. Ladies and gentlemen of the jury, are these your verdicts as read? So say you one, so say you all.
Okay, this time, ladies and gentlemen, the clerk is going to ask you a question and just ask that you respond yes or no.
Juror number 1 is, are these your verdicts as read?
Yes.
Juror number 2, are these your verdicts as read?
Yes.
Juror number 3, are these your verdicts as read?
Yes.
Juror number 4, are these your verdicts as read?
Yes.
Juror number 5, are these your verdicts as read?
Yes.
Juror number 6, are these your verdicts as read?
Yes.
Juror number 7, are these your verdicts as read?
Yes.
Juror number 8, are these your verdicts as read?
Yes.
Juror number 9, are these your verdicts as read?
Yes.
Juror number 10, are these your verdicts as read?
Yes.
Juror number 11, are these your verdicts as read?
Yes.
Juror number 12, are these your verdicts as read?
Yes.
Mr. Palmer, if you please stand.
In the Superior Court of Camden County, State of Georgia versus Jason Michael Palmer, case number SUCR 2024-000113. Verdict form, we the jury find as follows. Count 1, malice murder. On the charge of malice murder, we find defendant guilty of malice murder. Count 2, felony murder. On the charge of felony murder, we find defendant guilty of felony murder. Count 3, aggravated assault. On the charge of aggravated assault, we find the defendant guilty of aggravated assault. Count 4, concealing the death of another. On concealing the death of another, we find defendant guilty of concealing death of another. So say we all, this 29th day of August 20.
I wish to inspect the verdict form.
No, Your Honor.
Anything from either side before I release this jury?
No, Your Honor.
All right. If you retire to the jury room, please.
All rise.
We've got some fast breaking news, folks. Look at this. The tie is a total mess. We've got a verdict inside the courtroom. Do we have Matt Johnson on the line, or is he going inside the courtroom? He's going in the courtroom. Do we have a video feed of what's happening inside? There it is. Do we have audio from inside the courtroom? We do have audio. She's standing. That tells me they're waiting for either the judge or the jury to enter the courtroom.
The jury have returned. And who is the foreperson? Please stand. Okay. Has the jury reached a verdict?
Yes.
Is it unanimous?
Yes.
Please hand the verdict forms to Madam Bailiff. Thank you. All right, after having reviewed both verdict forms, the court finds that there are no errors or omissions in the filling out of the verdict forms. Madam Clerk, please publish the verdict.
In the Circuit Court of the 5th Judicial Circuit of the State of Florida in and for Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361. Verdict as to count 1. We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of second-degree murder. Was the defendant in actual possession of a firearm? Yes. Did the defendant discharge a firearm? Yes. Did the discharge cause great bodily harm? Yes. So say we all, dated this 13th day of September. Verdict as to count 2. We, the jury, find as follows as to count 2 of the charge. The defendant is not guilty. So say we all, dated this 13th.
Does counsel for either the state or the defendant wish to have the jury polled?
Defense does, Judge.
All right, Madam Clerk, please poll each juror. Consideration of this case, I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from your attorneys, or elsewhere. From the attorneys or elsewhere, it will be up to you to decide whether to preserve your privacy as a juror. Thank you so much for your time and attention and patience this week. Our system of justice would not work without good people such as yourselves. You are excused from further jury service. Thank you and have a nice night.
Welcome back to Court TV Live. I'm Ashley Wilcott in for Michael Ayala. Breaking news. I'm a little surprised, but 3 hours, 17 minutes in, we have a verdict. This is in the Florida case of Cadell Piedrahita, the case we've been bringing you. We know there is a live pick. He's at the defense table. His attorneys are there. Not very long deliberating, 3 hours, 17 minutes. This is the one in which he said it was self-defense. He claims that Alexis Palencia, who is the victim in the case, had a gun, and that he was in fear of his life and his son's life when he shot Alexis in self-defense. He faces 2 charges, second-degree murder and aggravated assault against Cesar Sosa, because he also did allegedly point the gun at him and threaten him. So those are the 2 charges that he faces. Again, in the state of Florida, you see all the deputies lining up behind him. That is typical when there's a verdict. Let's see if we're able to hear and go inside the courtroom.
So she did you call the police or anything?
I texted.
Okay.
I texted you.
Can I put this in the book? All right, I'm told the jury has a verdict. Who's our interpreter? Okay, she's been sworn in? Swear her in, please. It's okay. Just make sure she's sworn in.
Good afternoon. You swear from the truly and mostly translate from Spanish to English and English to Spanish, and you have the ability to do so. Yes, I do. Can you push your sword before putting each other for the right now?
Be seated, everyone, please. All right, this is the state of Florida versus Cadell Piedrahita, case number F19-15954. I am told the jury has a verdict. State is ready to proceed?
Yes, sir.
Defense?
Yes, Judge.
All right, bring the jury in, please.
Yes, sir.
Be seated, everyone. State, you can see the presence of our jurors.
Yes, sir.
About the defense?
Yes, Judge.
Publish it.
Yes, Your Honor.
And then poll the jurors, too.
Yes, Your Honor. In the Circuit Court of the 11th Judicial Circuit in the 4 Miami-Dade County, Florida,
Case number F19-159554, Judge Alberto Milian, State of Florida versus Cadel Pedrejita. Verdict form. We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of second-degree murder. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense, and as a result of discharging the firearm, was the death caused to Alexis Valencia? Yes. Did the state prove beyond reasonable doubt that Alexis Valencia died as a direct result of second-degree murder? Yes. We, the jury, find as follows as to count 2 of the charge. The defendant is guilty of aggravated assault with a firearm. So say we all, the 16th day of September 2024, Miami-Dade County. Ladies and gentlemen of the jury, you have heard me read the verdict. As I call your name, if this is your verdict, answer yes. If this is not your...
Jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. These people did not ask for this job. They didn't want the job. The state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. And it is a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury.
Stern words from Judge Arthur, asking for decorum inside of his courtroom.
Not surprising from this judge that had it quite a few days during this trial when things were not going to schedule, and he had to remind,
these attorneys.
Those attorneys.
Absolutely. Let's go back in. The jury has made it inside the courtroom.
Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count 1. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count 1, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Yes, sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Yes, sir. Sir, is that your verdict? Yes. Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry. Yes. On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Yes. Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count 2, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Yes, sir. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes. Ma'am, is that your verdict? Yes. On the back row, sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Yes. Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count 3, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Yes, sir. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Yes, sir. On the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right, all 3 Verdicts appear to be unanimous. The court will enroll the verdict. All right.
Mr. Foreman, I understand that you have reached the verdict. Is that correct?
Yes, Your Honor.
If you would please hand the verdict to Becky.
Your Honor.
All right. Ask the clerk to publish the verdict, please.
Your Honor, in the case of 2023, GS 23 4013 and 4014, the state of South Carolina versus John T. Lavelle. Number one, as to the charge of murder, we, the jury, unanimously find the defendant, John T. Lavelle, guilty. Number two, as to the charge of possession of a weapon during the commission of a violent crime, we, the jury, unanimously find the defendant, John T. Lavelle, guilty. I certify that this is the unanimous decision of the jury, signed by Mr. Lyda, our foreperson. Ladies and gentlemen, if you agree these are the verdicts you reached in your deliberation room, would you please raise your right hand? I thank you.
Madam Clerk. All right, before I dismiss the jury, anything from the state?
No, Your Honor.
Anything from the defendant?
Hold the jury, please, Your Honor.
All right, hold the jury.
The verdict that was published was the verdict you reached in your deliberation room. I ask you, was it your verdict then, and is it your verdict now? When I call your jury number, please answer yes or no. Juror 150?
Yes.
225?
Yes.
87?
Yes.
100? 100?
Yes.
Okay. 211?
Yes.
229?
Yeah.
57?
Yes.
90?
Yes.
17?
Yes.
244?
Yes.
88?
Yes.
179?
Yes.
Was there anyone I did not call? Thank you.
Thank you, Madam Clerk. All right, anything else from the defendant?
Nothing, Your Honor.
Good afternoon, everyone. I believe you're 3929, is that correct? So you're the foreperson. And it's our understanding that the jury has reached a unanimous verdict, is that correct? On all counts? All right. If you could tender that to Mr. Collins, please. Put this in front of the documents. Thank you. I'm going to remind everyone of the decorum order. If you need to leave the room, you're welcome to, but please no audible outbursts. All right, jury verdict, count number one, as to Nevin Stanisic. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number one, murder in the first degree. Jury verdict, count number two, as to Kevin Mahoney. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number two, murder in the first degree, indicating on all of these that there is a signature by the foreperson. Jury verdict, count number three, Trolana Artkawiak. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number three, first-degree murder. Jury verdict, count number four, Ricky Olds, murder in the first degree. We, the jury, find Ahmad Alyssa guilty of count number four, murder in the first degree. Jury verdict, count number five, Denny Stong, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number five, murder in the first degree. Jury verdict, count number six, Lynn Murray, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number six, murder in the first degree. Jury verdict, count number seven, Terry Liker, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number seven, murder in the first degree. Jury verdict, count number eight, Jody Waters, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number eight, murder in the first degree. Jury verdict, count number nine, Suzanne Fountain, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number nine, murder in the first degree. Jury verdict, count number 10, Eric Talley, murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 10, murder in the first degree. Jury verdict, count number 11, Angela Peacock, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 11, attempt to commit murder in the first degree. And yes, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 12, Casey Taylor, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 12, attempt to commit murder in the first degree. And further, yes, the prosecution has proven that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 13, Hayden Steele, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 13, attempt to commit murder in the first degree, and further find that the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 14, Kajendra Malla, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 14, attempt to commit murder in the first degree, and further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 15, Jacqueline Keaton, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 15, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 16, Paul Johnson, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 16, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 17, Kimberly Breckus, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 17, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 18, Michael Hong, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 18, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 19, Tasia Barra Ford, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 19, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 20, Patrick Cruz, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 20, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 21, James Graham, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 21, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 22, Kelly Ray Dorr, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 22, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 23, Sarah Moonshadow, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 23, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict, count number 24, Sarah Moonshadow, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 24, attempt to commit murder in the first degree, and further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 25, Nick Edwards, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 25, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 26, Nick Edwards, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 26, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 27, Christopher Tatum, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 27, attempt to commit murder in the first degree. Further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 28, Christopher Tatum, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 28, attempt to commit murder in the first degree. Further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 29, Brian Capobianco, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 29, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 30, Pam Gimniak, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 30, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 31, Richard Stidell, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 31, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 32, Richard Stidell, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 32, attempt to commit murder in the first degree, and further, that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 33, Brian Pleiter, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 33, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 34, Brian Pleiter, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 34, attempt to commit murder in the first degree. Further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 35, Alexander Casera, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 35, attempt to commit murder in the first degree. And further, the prosecution did prove the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 36, Alexander Casera, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 36, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 37, Jenny Schmeitz, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 37, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 38, Jenny Schmitz, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 38, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 39, DJ Richard Smith, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 39, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 40, DJ Richard Smith, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 40, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 41, Brian Capobianco, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 41, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 42, Brian Capobianco, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 42, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 43, Brandon Braun, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 43, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 44, Brandon Braun, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 44, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 45, Michael West, after deliberation, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 45, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 46, Michael West, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 46, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 47, Jeffrey Brunkow, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 47, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 48, Samuel Kilburn, extreme indifference, attempt to commit murder in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 48, attempt to commit murder in the first degree. And further, the prosecution did prove that the defendant used or possessed and threatened the use of a deadly weapon. Jury verdict count number 49, Ilan Shakti, assault in the first degree. We, the jury, find the defendant Ahmad Alyssa guilty of count number 49, assault in the first degree. Jury verdict count number 50, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant Ahmad Alyssa guilty of count number 50, possession of a large capacity magazine during the commission of a felony. And further, the defendant did possess the large capacity magazine during the commission of a specific crime, during the commission of murder in the first degree, as defined. Jury verdict count number 51, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant Ahmad Alyssa guilty of count number 51, possession of a large capacity magazine during the commission of a felony. And further, the defendant did possess the large capacity magazine during the commission of a specific crime, the commission of murder in the first degree, as defined. Jury verdict count number 52, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant Ahmad Alyssa guilty of count number 52, possession of a large capacity magazine during the commission of a felony. The defendant did possess the large capacity magazine during the commission of a specific crime, crime of murder in the first degree, as defined. Jury verdict count number 53, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant Ahmad Alyssa guilty of count number 53, possession of a large capacity magazine during the commission of a felony. The defendant did possess the large capacity magazine during commission of a specified crime, murder in the first degree as defined. Jury verdict count number 54, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 54, possession of a large capacity magazine during the commission of a felony. The defendant did possess the large capacity magazine during the commission of a specified crime, murder in the first degree as defined. Jury verdict count number 55, possession of a large capacity magazine during the commission of a felony. We, the jury, find the defendant, Ahmad Alyssa, guilty of count number 55, possession of a large capacity magazine during the commission of a felony. The defendant did possess the large capacity magazine during the commission of a specified crime, murder in the first degree as defined. And juror number 3929. Are those your personal verdicts? Okay, I'm going to go through the rest of your juror numbers just in the order that they appear on my list, and I'll be asking each of you that same question. Juror number 3238, raise your hand. Were those your verdicts? Juror number 3743, raise your hand. Were those your verdicts? Juror number 3852, raise your hand. Were those your verdicts? Juror number 3712, raise your hand. Sir, were those your verdicts? Juror number 3129, were those your verdicts, ma'am? Juror number 4106, were those your verdicts? Juror number 3735, sir, were those your verdicts? And juror 2886, ma'am, were those your verdicts? How about 4357, ma'am, were those your verdicts? And juror 4116, sir, were those your verdicts? And last 2890, ma'am, were those your verdicts? All right. All right, folks. You have now completed your duties as jurors in this case, and you are discharged with the thanks of the court, the parties, everyone involved, your community. You have done a great service.
Ready, Your Honor?
Yes.
The jury's now heading to the courtroom.
Ladies and gentlemen of the jury, have you reached a verdict? We have, Your Honor. Four person. If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict?
Yes.
Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes.
Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made.
Thanks again for your time and attention. You are excused.
Jurors excused.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be November 1st?
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet and pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
The servants will give that, we'll give those to you.
Thank you. You may adjourn court.
All rise.
All right, stand up.
Breaking news out of Ohio. We have a verdict in the case against Toby Madden, the stabbed 55 times murder trial. So our clock is stopped there. An hour and 15 minutes. This jury has been deliberating.
Yeah, it didn't take long, and if you missed it earlier, there's a live look inside the courtroom. We're told by our team it's not going to be very long before this verdict is read. All the parties were very close, so once word gets out, which has already happened, presumably this could be happening at any minute. So if you missed it earlier this morning, he had an outburst in front of the jury and basically was disrupting the courtroom proceedings, asking them to look at a certain exhibit back in and then it was a lot. And one would think that went right to the state's case against him, and that he was volatile, he was unable to control his emotions, and that behavior that they saw today in that courtroom was the same behavior that he exhibited when...
And his defense attorney had done a fine job. Don't know if he would have been able to get him a lower count, but his attorney had laid this out in a way that could have convinced a jury that he did not intend to kill his girlfriend, that he was in a heat of passion, that he was just starting to stab her and then didn't stop, that he tried to save her life with CPR. I mean, it was a very well-crafted closing argument. But then in that rebuttal is when that outburst happens.
Yeah, and I guess you could take it either way, but I don't think it helped him at all. Let's bring in Eric Faddis. He's watching along with us. Eric, our apologies. If we cut you off, it's because we're getting word that the verdict's about to be read. Your thoughts? Hour, 15 minutes, not a ton of time to go back and deliberate. It likely doesn't look good for the defendant.
Ted, that is a terribly short period of time, especially in a first-degree murder case. And you know, like you said, I can't help but wonder how the jury was interpreting some of these multiple outbursts over the course of the trial and what they thought that meant as to Mr. Madden's demeanor and what he's capable of.
Yeah, that first outburst was, of course, the one that he did outside of the jury's presence, but it doesn't mean that they didn't see it, because he, before the jury was even brought in for opening statements in this case, he told his daughter in the gallery, "Please forgive me, I'm responsible, I'm sorry." And that moment, the state just wove into the rest of their case. They brought it up in opening statement. They played a clip of it inside of the courtroom. So this jury, no doubt, understands his outbursts and how he's been. Could it go to this heat of passion, or maybe they think he has some kind of diminished capacity because he can't keep it together inside of a courtroom?
You know, Julia, that's what I was wondering is if defense was going to touch a little more on the mental health piece, especially with how these outbursts have transpired and what the jury has seen. You know, could that even garner some potential sympathy if handled the right way by defense? Possibly, but it wasn't really a road that they hammered on much, and it could have been helpful to do that.
Yeah, and an hour 15, I don't think they all agreed on going down that road. If this was an extensive deliberation, maybe. Let's remind our viewers what happened after the state's rebuttal closed this outburst from the defendant in front of the jury.
Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that exhibit
jurors, I'm going to ask you to retire to the jury room.
Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Recess at this time.
Look at state number, exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get there. Okay, now we're
right.
Okay, so
I look at my comment.
The court is not going to tolerate. Let me get back on from there.
You're not, listen,
right,
what you're not going to do is I'm not going to sit here and allow you to.
Thank you.
This is what you did the last time went on.
Again, now a live look at the seal in the courtroom. Eric, that couldn't have helped his cause. It's not like they scurried back there. Oh, let's get out Exhibit 66 and see what this guy's talking about. This was just it likely was unnerving.
Yeah, Ted, of course. And you look at the look on the defense attorney's face. He just looks exasperated. He's trying to kind of keep this together, make the best presentation he can, as Julia said. And unfortunately, his client kind of continues to stymie those efforts with these volatile outbursts.
All right, this is a live look inside of the courtroom. You see, they haven't gathered yet, so we won't go in at this point because they aren't on the record. We don't have any audio. Let's do this. Let's squeeze in a break because as they are gathering, we should be able to get something live and on the record after this break. You're watching Court TV, your front row seat to justice.
Welcome back. Perfect timing. The parties have gathered in Ohio. The verdict is in the Toby Madden case. The jury hasn't been brought in yet. The defendant is not in the courtroom, and a sergeant is about to take the stand here. Something must have happened with the defendant concerning the defendant. Let's watch.
Okay, please be seated. We're back on the record in State versus Madden, CR 22121675. Mr. Burst and Mr. Hahn are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden. Mr. Madden is appearing remotely at another location in this building, and he is able to hear these proceedings. Okay, so before I've been advised that the jury has a verdict. However, some concerns were brought to my attention during the recess that I'd like to address at this time, and I'd like to ask Sergeant Owens to please take the witness stand. Okay, Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And Sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state?
Thank you.
Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right. So I understand the jury has reached a verdict, and we are waiting on the state's representative.
You should be here momentarily.
Okay. Well, we'll go off the record for just a moment.
All right, let's bring back in Eric Faddis, criminal defense attorney, who is standing by. Eric, these comments that are being made by this defendant has to be on the record, because you don't want on appeal there to be an issue with the defendant saying, I wasn't there for my own verdict.
Yeah, Julia, that's exactly right. Yet another bizarre turn of events in this Madden case. And it was smart, I think, of the judge to have the officer come in and actually give testimony on the record as to what happened. Because later on, if that didn't happen, Mr. Madden could say, hey, I should have been present for this verdict and I wasn't. And that's a ground for appeal. But here, there's a reason he wasn't present, and that's on the record.
All right, jury walking in. You can see the judge standing as the jury files in. We will go in and listen to see what their verdict is. Again, the defendant not in the courtroom, in that adjacent room. Not sure if we'll be able to see him or not during the reading of the verdict, but that is the situation.
He can see what's happening inside of this courtroom. We even saw him mouthing, "That's not what I said."
Right.
Seeming to disagree with something having to do with him not being there in the courtroom.
He has been all over the map, that is for sure.
Okay, ladies, and I understand that you have reached a verdict in this case. Is that correct?
Yes.
Okay, and who is our foreperson? Okay, would you please return the verdict forms to Mr. Halcomb? Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. And the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
No, thank you.
Okay. Okay, ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your patience with us during some of the breaks that we had to have, and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is the finest in the world, and it is so very important in preserving the property and liberty and the rights of citizens that you are willing to agree to serve as jurors in this case. By your being here and participating, you are helping to guarantee the continued existence of law and social order in our society. So you have my thanks. And I'd also like to thank the attorneys in this matter for their professionalism. I have had you under an order that you could not speak about this case. Now that you have rendered your verdict, you are permitted, I will release you from that order. You are permitted to speak with anyone that you wish to about this case. You are not required to speak to anyone, but that will be your choice alone. In addition, I gave you restrictions about looking at things and investigating things. All of the orders numbers that I gave you you're now released from those. And again, I appreciate your service very much. So you are discharged with the thanks of the court. I would ask that you return briefly to the jury room. Thank you.
Guilty as charged for Toby Madden, and you see there, that's who everyone's heart is with right now. The daughter of the victim, the daughter of the defendant. What a complicated position McCallum is in.
And sat through this entire trial, including the medical examiner's testimony. She saw the photos of her mother butchered to death. All right.
Members of the jury, my understanding is you have reached a verdict. Is that correct? Okay, if you'll hand the verdict form to court security. Madam Clerk, if you will publish the verdict.
State of Florida versus Bree Kristen Kuhn, case number 21CF1301. Verdict. We, the jury, finds as follows as to the offense charged in the indictment. Guilty of first-degree premeditated murder as charged. So say we all, this 27th day of September 2024. Juror number 109, AD, 4-person.
Do any of the attorneys wish the jurors to be polled?
Nothing to say, Judge.
Yes, Your Honor. All right, Madam Clerk, if you'll poll the jurors, please, by number.
Juror number 185TR, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 198IO, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 77TS, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 263JJ, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 112AB, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 195EK, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 216DJ, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 44AK, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 267WP, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 122JO, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 66MS, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 109AD, is this your verdict as well as the verdict of the jury as a whole? Yes. Thank you.
Ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations at this time, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you from the media, from the attorneys, or elsewhere. It will be completely up to you to decide whether to preserve your privacy as a juror. With that, again, I thank you for your time and attention to this case. You served a very important function in our judicial system. As I said in jury selection on Monday, there are many countries in the world today that their citizens do not enjoy the right to a jury trial, but we here in America still do, and you were part of that over the course of this week. So with that, again, thank you for your time and attention, and you're now excused.
You've heard the arguments from both sides, and it didn't take long for the jury to reach a verdict. Less than 30 minutes.
We, the jury, unanimously find the defendant on the charge of murder of Davis McClendon guilty. Signed, four-person. Ladies and gentlemen of the jury, if this is still your verdict, will you please raise your right hand?
Okay, let the record reflect 12 hands have been raised. I want to thank you for your jury service. What matters the most to the court is that my jury performs its duties efficiently, conscientiously. Your verdict that you reach does not matter to me, but what matters is that you perform your duties as you're supposed to. As I told you on, I think it was Wednesday when we came back, I was pleasantly surprised.
Oh, and that right there, the most emotion we've seen from Bud Ackerman throughout this whole case. He sat there with a poker face on day in and day out, and you saw his head drop. It seemed like his shoulders sunk in. It looked like he was, perhaps on the verge of tears there, learning the news that the jury found him guilty in less than 30 minutes' time. Ooh, that's fast. Let me talk about it with a very seasoned trial attorney. You know him and love him, Tommy Pope, on the show today. Tommy, let's talk about the speed here. Our field producer, Tiffany Smith, had the stopwatch there and counted 26 minutes for this, 26 minutes to get this verdict. And we were talking on our morning editorial meeting saying, you wonder if that's a court TV record. I mean, in all the years, and maybe in courthouses around the country, too. That's unusually quick. Have you ever seen a jury come back that fast?
I've seen some, and it always scares you as a prosecutor when they come back that quick. Of course, this case was in South Carolina. I wanted to point out John Metters was an assistant solicitor back when I first started my career, and I'm pretty sure my first trial was against Jack Swirling. So I think the reason they went so fast, those two guys are getting old, certainly not me, and they just needed them to be able to hurry up and sit down before they fell asleep or something. But seriously, I think, the evidence was overwhelming. I was thinking about what Jack said in closing regarding the hitting of the BMW, and it reminded me almost of a circumstance where you see somebody shoot and kill somebody, and then they kick the body. Right. So I've already hit you, and now I'm going to tear your car up too on the way out.
Mm-hmm. Oh, that's good. That's good. You think it had to have happened in two separate events, huh? Yeah. That there's no way it was, this was just such a bizarre incident, wasn't it, Tommy? The meetup and the wife, there were some people who think that maybe the wife was wrong here in trying to kind of get these guys together, like they needed to have a meeting. What is there to discuss at this point? The divorce is happening. She's moved on. What do you think about her in terms of an actor in all this? Do you think she has unclean hands?
I think if they're unclean hands, it's the fact that, and it happens all the time, the fact that you didn't wait the extra 4 weeks till everything was over. And so again, people are human, their emotions, their need for affirmation or to move on or whatever the case may be. I mean, the only thing I can see, the only piece of even legality he had to hang his hat on was, like he said, they were still married. But you could tell from her testimony, you could tell from what was going on that, I hate to use the Garth Brooks example, but she's going to make it and he never will. She's moved on and he couldn't. And unfortunately, he clung to that so hard and so tight that it caused him to take a life and for him to spend the rest of his life in jail.
Mm-hmm. Right, Tommy. Yeah, it got messy, trying to control the situation and I think, keep his marriage together, keep his family together. It seems like watching this, hearing the story, it's almost like he was in a bit of denial, about what was going to happen. And now he's going to be locked up, as you've said, for the rest of his life.
Let's go inside. The judge has entered and taken the bench.
The jury has reached verdicts in the case. Mr. Fryer, our foreperson, looks like you would hand those verdict forms to Deputy Laraway. All right, finding no errors or omissions in the verdict forms, Madam Clerk, if you would please publish the verdicts.
In the Circuit Court of the 4th Judicial Circuit and in Fort Clay County, Florida, case number 2020 CF 392, State of Florida versus Corey Louise Baldwin. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. We further find the killing was done during the commission or attempted commission of a felony to wit burglary. Count 2. We, the jury, find the defendant guilty of burglary as charged in the indictment. We find the defendant committed an assault during the commission of the offense. We find the defendant did not commit a battery during the commission of the offense. We find the structure was a dwelling. Count 3. We, the jury, find the defendant guilty of tampering with evidence as charged in the indictment. So say the all. Senator Greenfield Springs, signed by the foreperson, October 14th of 2024.
All right, does either party wish the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you please poll the jury.
Yes, Your Honor. Jury number 5 is issued true verdict. Jury number 9 is issued true verdict. Jury number 20 is issued true verdict.
Yeah, I think if you would go, Sarah, with the juror numbers that are happening, I'll start with the juror number 1.
I'll start with juror number 1.
Yes, yes,
Juror
ma'am.
number 1 is issued true verdict.
Yes.
Juror number 2 is issued true verdict.
Yes.
Juror number 3 is issued true verdict. Juror number 4 is issued true verdict.
Yes.
Juror number 5 is issued true verdict. Yes. Juror number 6 is issued true verdict.
Yes.
Juror number 7 is issued true verdict.
Yes.
Juror number 8 is issued true verdict. Yes. Juror number 9 is issued true verdict.
Yes.
Juror number 10 is issued true verdict.
Yes.
Juror number 12 is issued true verdict.
Yes.
And juror number 13 is issued true verdict.
Yes.
And for the record, we lost a juror at the beginning of the trial, or at the end of the first week, so that's why the numbers are slightly off. All right, ladies and gentlemen, based on your verdict of guilty as charged of first-degree murder, our work is not done. We're going to go down to the second phase of the trial, the penalty phase, as you heard it referred to earlier. We're going to start that on Wednesday. We're going to take tomorrow off. There's some matters that we need to attend to that don't concern you and don't need your presence here.
At this point, I am going to ask the foreperson to please stand. Juror 5. And have you reached a verdict?
Yes, we have.
Was it unanimous?
Yes, it was.
Has the verdict been filed in or filled in and signed and dated by you?
Yes, it has.
And if you would please hand the verdict to Deputy Solomon. Thank you, Deputy Solomon, for handing that up. I'm going to ask counsel to approach and take a look at the verdict form.
Every state's a little different. This particular judge is having the attorneys look at the form of the verdict to make certain they agree it's in its proper form. Typically, you see the judge does that without the attorneys looking at it. A little bit different here, and this is a 20-month-old Quentin Simon that mother right there that you're looking at is accused of murdering. The jury's been out 6 hours, 46 minutes. Let's go back in for this verdict.
As to the verdict, it reads as follows. We, the jury, find as follows: malice murder. We find the defendant guilty. Count 2, felony murder. We find the defendant guilty. Count 3, felony murder. We find the defendant guilty. Count 4, concealing the death of another. We find the defendant guilty. Count 5, false report of a crime. We find the defendant guilty. Count 6, making a false statement. We find the defendant guilty. Count 7, making a false statement. We find the defendant guilty. Count 8, making a false statement. We find the defendant guilty. Count 9, making a false statement. We find the defendant guilty. Count 10, making a false statement. We find the defendant guilty. Count 11, making a false statement. We find the defendant guilty. Count 12, making a false statement. We find the defendant guilty. Count 13, making a false statement. We find the defendant guilty. Count 14, making a false statement. We find the defendant guilty. Count 15, making a false statement. We find the defendant guilty. Count 16, making a false statement. We find the defendant guilty. Count 17, making a false statement. We find the defendant guilty. Count 18, making a false statement. We find the defendant guilty. And count 19, making a false statement. We find the defendant guilty.
Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the 9th Judicial Circuit in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror in seat number 1, is this your true and correct verdict?
Yes, it is.
Juror in seat number 2, is this your true and correct verdict? Yes, it is. Juror in seat number 3, is this your true and correct verdict? Juror in seat number 4, is this your true and correct verdict?
Yes.
Juror in seat number 5, is this your true and correct verdict?
Yes.
Juror in seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter.
Circumstances, just reminding
All right,
folks.
understand y'all
All right,
fixed the
let's get
verdict.
back in the courtroom.
Yes, sir. And is it signed by you as foreman? Yes, sir. All right, if you'll hand it to the bailiff, then I'll review it, and then I'll hand it back to you. All right. If you'll hand that back to the foreman. All right, sir, as foreman, I'm going to have you stand and publish your verdict. You can do that just by saying, "We, the jury," and then to each count, say, "We find the defendant guilty or not guilty," as to each count.
All right. We, the jury, as to the count 5, we find the defendant guilty. We, the jury, as to count 4, find the defendant guilty. We, the jury, as to count 3, we find the defendant guilty. We, the jury, as to count 2, find the defendant guilty. And we, the jury, as to count 1, find the defendant guilty.
All right, we'll hand it back to the bailiff. Madam Bailiff, you just show it to counsel.
We have breaking news out of Ohio. The verdict in the medical assistant murder trial for Quentin Nixon has come in.
This is a bench trial, so the judge is on the bench. Let's go back. Let's go into the courtroom in Ohio and see what she has decided about the defendant's fate.
There will be no outbursts of any kind, and if there are, you will be asked to leave the court and not return until this court is done with its business. Thank you. Let me start by saying, Mr. Nixon, I'm going to commend you for your behavior throughout the trial. You were very respectful of the process and the court. That being said, I do believe you did a great and grave disservice to yourself by representing yourself. There are many nuances and trial strategies that a seasoned attorney such as Mr. Perry would have been able to employ throughout this trial. That being said, having decided to represent yourself and waive your right to the jury trial, the responsibility falls on me to render verdicts in these cases. In the case involving the death of Tony Westover, in count 1, you are charged with murder in that the state must prove that you purposely caused the death of Tony Marie Westover with a firearm specification attached. Purpose to cause the death of Tony Marie Westover is an essential element of the crime of murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Tony Marie Westover. Purpose is a decision of the mind. To do an act with a conscious intent to produce a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances and evidence. The defendant is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant, when using deadly force, did not act in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation, giving rise to the shooting or attempted shooting of Tony Marie Westover, or the defendant did not have reasonable grounds to believe that he was in imminent danger or death or of great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in imminent danger of death or great bodily harm, or the defendant used unreasonable force. Unreasonable force is a person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. If the defendant used more force than reasonably necessary, and if the force used is so greatly disproportionate to the apparent danger, then the defense of self-defense is not available. Greatly disproportionate. In deciding whether the force used was greatly disproportionate to the apparent danger, I must consider whether the force used shows revenge or a criminal purpose. In count 2 of and I will add that the defendant has alleged self-defense in all 3 counts, counts 1, 2, and 3, in the indictment. In count 2, the defendant must have caused the death of Tony Marie Westover as the proximate result of committing or attempting to commit felonious assault, also with a firearm specification. The state must prove the elements of felonious assault as to the murder contained in count 2 of the indictment, as well as all of the elements of felonious assault. Felonious assault, the defendant must have knowingly caused or attempted to cause serious physical harm to Tony Marie Westover by means of a deadly weapon, to wit, a firearm. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of facts, that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. In addressing whether your actions were in self-defense, I find that the state, must find, or the state must prove that there was serious physical harm, which is any physical harm that carries a substantial risk of death. In count 5, because count 4 was dismissed prior to the trial beginning, the defendant must have knowing that an official proceeding or investigation was in process or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence. For each of the charges contained in counts 1 through 3, there are also attendant firearm specifications. The state must prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing those offenses and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosion or combustible propellant, I may rely on circumstantial evidence, including but not limited to the representations and actions of the defendant while exercising control over the firearm. As to the charge of improper handling of a firearm in a motor vehicle, in case 2206-2276, the defendant must have knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle, and the accompanying forfeiture specification of the Riley Defense, Inc., RAK 47, serial number B11765. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Tony Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Tony Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022. And furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc. RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count, and I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Tony Marie Westover, and or that you used unreasonable force against Tony Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised Code 294125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 for merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 292914 B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, attempted murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications. Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 292914 B1G. Mr. Perry, would you like to talk to Mr. Nixon about a PSI, or is he prepared to waive that right?
I would, Judge, just a second.
Sure.
Thank you. Madam Foreperson, do you have a verdict?
Yes, we do.
Could you please hand the verdict form to the bailiff? Thank you very much, sir. Thank you. Madam Clerk, can you publish the verdict? Thank you.
In the case, State of South Carolina versus Craig Anthony Lewis, indictment numbers 2019 GS 15 00138, charges arson in the 1st degree. Indictment 2019 GS 15 00129, the charge is murder. As to the charge of arson 1st degree, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. As to the charge of murder, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. And this was signed by the foreperson on today's date, November 7, 2024.
Thank you. Would either party like the jury to be polled?
No, Your Honor. No, Your Honor.
All right. Thank you. Members of the jury, thank you very much for your service. Our entire judicial system could not function without people like you who are willing to give up your free time, your time from work and family to come in and make these difficult decisions. I thank you for your attention. I thank you for your hard work. I know it was a difficult decision for all of you to sort through all of that information, all that you heard, all that you looked at, and come up with a verdict. And I appreciate it. If any of you want to discuss any of this with me, you're welcome to give me a call at some point. can be found in the Beaufort Clerk of Court, through the Beaufort Clerk of Court. You are welcome now to go discuss this case with anyone that you would like. You are not required to, however. If anyone begins to bother you or harass you or anything about your verdict, please contact me through the Colleton County Clerk of Court's office immediately, and we'll have it taken care of. Does anyone have any questions? All right, then. I would thank you all for your verdict. Any objection to releasing this jury?
No, Your Honor. None from the defense.
Thank you all very much.
And now to California for another something else you need to know tonight. Jurors have decided the fate of the defendant in the killed in the crosswalk murder trial. Prosecutors say Brandon Janik ran a red light and killed a 47-year-old named Joshua Gillian as he was walking across the street. He's charged with second-degree murder, gross vehicular manslaughter, felony hit and run, and felony DUI. Gilliland was on his way to work at Cheers, a bar where he had worked for more than 20 years when he was killed. Witnesses say several people stopped to help the victim, but Brandon Janik did not, and he's now been found guilty on all counts, including murder. He wiped away tears as the verdict was read.
In the Superior Court of the State of California, in and for the County of San Diego, Central Division, the people of the State of California plaintiff versus Brandon A. Janik defendant. Case number SCD 300413. Verdict count 1, second-degree murder. We, the jury, in the above entitled cause, find the defendant, Brandon A. Janik, guilty of the crime of second-degree murder in violation of Penal Code Section 187A, as charged in count 1 of the information, dated November 7, 2024, signed by juror foreperson number 4.
Janik faces 15 years to life behind bars, plus an additional 8 years for insurance fraud charges. He's going to be sentenced next month.
Let's go in now together to hear the verdict.
Good morning. Ladies and gentlemen of the jury, good morning to you all, and thank you all very much for your cooperation from the first day of this proceeding up to now. We understand the jury has reached a verdict, so will the foreperson please rise. Good morning, sir. Good morning. Has the jury reached a verdict?
Yes.
Have you signed and dated the verdict form?
Yes.
Can you please hand them over to Monty? You may have a seat, sir. Counsel, Ms. Villa, please stand. Madam Clerk, would you please read the verdict?
In 1 FFC 19-759, State of Hawaii versus Dixie Denise Villa. As to the charge of manslaughter, we, the jury, in this case, find the defendant, Dixie Denise Villa, guilty as charged of the offense of manslaughter. Special Interrogatory 1. If you find defendant Dixie Denise Villa, also known as Denise Villa, guilty of an offense, you must answer the following question. Did the prosecution prove beyond a reasonable doubt that the offense was committed against a child by a person that had legal or physical custody of that child? Your answer to this question must be unanimous. Yes.
Thank you.
Welcome back to Court TV Live. We have a verdict in the case against Chloe Driver, the young mother accused of killing her daughter, Hannah. 1-year-old little Hannah stabbed to death by her mother. She admits she did it, but the defense here was not guilty by reason of insanity. Will the jury buy it? Let's go into the courtroom and find out what the verdict is.
Thank you. You can be seated. Mr. Foreman, has the jury reached a verdict?
We have, Your Honor.
Is it signed and dated by you as foreman?
Yes, it is.
All right, if you could give the verdict form to the bailiff, I will inspect it before I ask you to publish it.
He'll give that back to the foreman. Mr. Foreman, if you will stand, Mr. Iver and counsel, if you will stand, if you will read the jury's verdict, please.
For each count below, we, the jury, find the defendant, count 1, malice murder, guilty beyond a reasonable doubt, but mentally ill. Count 2, felony murder, aggravated assault, guilty beyond a reasonable doubt, but mentally ill. Count 3, felony murder, cruelty to children in the first degree, guilty beyond a reasonable doubt, but mentally ill. Count 4, aggravated assault, guilty beyond a reasonable doubt, but mentally ill. Count 5, cruelty to children in the first degree, guilty beyond a reasonable doubt, but mentally ill. So found this 20th day of November, 2024.
Thank you, sir.
Jurors, please remain standing. Defendant, please remain standing. All others may be seated. Thank you.
Pardon, may I inquire?
You may inquire.
Thank you. What say you, Madam Foreperson, as the jury agreed upon its verdict in Hampshire County Indictment 2380 CR 0032, Commonwealth versus Brian Camp?
Not guilty.
You have agreed upon your verdict?
I have.
Yeah, that's okay. If you could please give the verdict slip to the court officer.
Inquire.
What say you, Madam Foreperson, as to count 1 of Hampshire County Indictment charging the defendant Brian Camp with manslaughter, is he not guilty or guilty as charged?
Not guilty.
Members of the jury, hearken to your verdict as the court will record it. Upon your oath, you do say that the defendant Brian Camp is not guilty. This is a unanimous verdict of the jury, so say you, Madam Foreperson?
I do.
So say you, all members of the jury?
Yes. You do.
Thank you.
All right, ladies and gentlemen, I want to thank you. I'm going to have you step back out to the jury room. I do want to come back and personally thank all of you for your service here today. It was with great thanks that we, on behalf of the community, thank you for your service in this matter, and I'll be back to see you and the alternate jurors in just a moment. Thank you.
Welcome back. Breaking news in the jury in New York deliberating the fate of Daniel Penny has come to a verdict. Not guilty is their verdict. The Marine veteran who used a chokehold on a subway rider has been acquitted. This clears him of all criminal negligence here in Jordan Neely's death last year. A more serious manslaughter charge was dismissed last week after the jury was deadlocked on that count. The jury came back Friday, said we're deadlocked on the more serious manslaughter count. At that time, the prosecution wanted to dismiss the charge, which the judge agreed with. That allowed the same jury to come back today and start to deliberate count 2, criminally negligent homicide. On Friday, the defense didn't want that. They wanted a mistrial granted for both of these charges. The judge agreed with the prosecution, but guess who wins? The defense, because the jury comes back on the lesser. Criminally negligent homicide was what they were deliberating, and today they have come back with a not guilty verdict. There were no cameras allowed in this case. That is the breaking news at this hour. Joseph Tully watching along with us. And Joseph, one of those things where strategically the defense wanted the mistrial declared last week, but turned out that it worked out in their favor. This jury didn't take long today. Didn't even get to the lunch break, coming back not guilty on this count 2.
Yes, it's very surprising. I mean, this is why criminal defense world is so shocking and has so much adrenaline to it. Here you have a situation where the jury couldn't decide on the more serious charge. They were deadlocked. That means there were some people who wanted to vote guilty. So the prosecution and the judge took that off the table and said, okay, don't worry about deadlocking on the first charge. We'll just go to the lesser charge of criminal negligent homicide. And the jury came back not guilty unanimously on that, which is very surprising given that they were deadlocked on the more serious charge.
Yeah, it is hard to get you. Could it be frustration from the jurors as a whole? And we didn't know the split, which, if it was 11-1 or 10-2, But, man, did you agree with the defense strategy to argue that there should be a mistrial granted on both charges once they came back deadlocked on the higher charge? One would think that that's the way to go, especially considering this, he is out on bail.
Certainly, yes. And the reason why you do that is because in criminal law, on the defense side especially, whenever you have something for sure, you grab it, even though it's not 100% of what you want. So here, they had a situation where it was a deadlock. They wanted a mistrial. Judge, start everything over again. You take the for sure thing of a deadlock, which is a not conviction. Anytime the government doesn't get what it wants, that's a win for the defense. So here the judge and prosecutor tried to take that away from the defense, and it ended up backfiring on them, which is very surprising.
Daniel Penny accused of, he put Jordan Neely, this individual on the subway, into a chokehold, and the state says that this was manslaughter. The defense said that this was nothing of the sort, that he was coming to the aid of fellow passengers. Let's watch, remind everybody of the body camera video. This was captured on video, but also the Penny was talked to immediately when this happened, and it was on body camera video from responding officers. Take a listen.
You're posing him. I feel a pulse. You feel the pulse? Keep breathing, right? Try it on the wrist. Try it on the wrist. This one. You got pulse. You got pulse. You breathing? I feel like. Nah, I feel the pulse. You got a pulse. You got a pulse. Oh, man. He put him on pulse. Stay with me. He's breathing. Relax. Get off the train. How about you get off the train?
All right, that was they were tending to to Jordan Neely there on the train. Joseph, this is one of those cases that really divided the country. Did it get political, this prosecution, in your estimation? It sure did rile up a lot of folks on both sides.
Sure, I think it absolutely was political. We have different dynamics here. We have the person who died was black. The person who claimed self-defense was white. That always comes to the forefront. Not always, but frequently comes to the forefront in terms of the news, which I think is used as a tool of division, which we need to not have division. We need to have unity. Here, one thing that we should all be able to learn from is that this is also something that could have been avoided. This speaks to the mental health crisis in this country. Mr. Neely was not well. He had mental health problems, documented history, and it really is a horrific tragedy that it resulted in his death rather than just get treatment for mental health, which could have been provided under different circumstances.
Yeah, and a lot of people brought that up, that the defendant in this case was sort of not just Daniel Penny, but also, society in general, because it's not just the New York subways, it's mass transit in every major city. You have mentally ill people using mass transit as a place to find refuge and warmth, and also that interaction has created these tense scenarios, and it just is a part of that. What does the verdict say to you?
I think the verdict says that society is wanting safety. They're wanting, protection from people who are out there who could potentially be violent. And again, Mr. Neely, it was said that he was threatening the other passengers, and you quite clearly have to say that what happened is the jury putting protection and self-defense over issues like racial justice or racial division, where they're deciding, okay, let's drop the black and white thing. This is an issue of protection, and we want protection. Right. We want to be safe.
We're going to start with the case in Mississippi for Sheldon Tim Harrington Jr.
Been out 9.5 hours, I think. Have you reviewed all of them thoroughly? I'm going to declare a mistrial. I appreciate your effort.
All right, so mistrial declared by the judge Wednesday after over 9 hours of deliberations. The jury was unable to reach a unanimous decision. Harrington, seen here after the court made that declaration, showed little emotions. He left the courtroom with his defense team. While the family of victim Jimmy J. Lee were visibly very emotional. Jay was a prominent member of the LGBTQ community at Ole Miss, and his body has never been recovered, but a court has declared him legally dead. Now, we want to turn to North Carolina.
We have some breaking news for you. There is a verdict in the case we have been watching out of Vermont. This is the case for Joseph Ferlazzo. The jury did deliberate for 3 hours and 30 minutes. The judge has just called for the jury. Let's go in.
Please be seated. Ms. Reno, I understand the jury has reached a verdict. How do you find Mr. Palazzo on the count of first-degree murder, guilty or not guilty? Ms. Jantz, would you like us to poll?
I would, please.
And Mr. Zago, is that your verdict, guilty or not guilty?
All right, if you've noticed that we can't hear the audio right now, they are saying the jurors' names. So, of course, we cannot reveal the names of the jurors in this case. But what we can tell you that we have heard the verdict, and he is being found guilty. The jurors have found him guilty of first-degree murder. 7 women and 5 men have been deliberating this case. Took them over 3 hours to reach this verdict, saying that he's guilty of first-degree murder for the death of his wife, 22-year-old Emily. Let's listen again.
So much for your service. It's clear you were very thoughtful throughout the trial. Really appreciate how you were always on time, you were always listening, taking notes, and really studying the evidence as it was coming in. Really appreciate your time in this case. Thank you, and you're excused with great thanks of the court. All right.
Judge, just obviously that Mr. Ferlazzo continue to be held without bail.
Judgment of guilt entered at this time.
Yes.
And I'd like the opportunity to file post-trial.
Yes. Thank you, Judge.
I know what the time limits usually are, but I'd give you a bit more if that's what you want.
I do. In light of the holidays coming up, I'd like until January 15th.
Any objection?
No, Judge.
January 15th, any response from the state will give you 3 weeks to respond, if that's all right with you. And so we'll set it sometime in mid-February. So 3 weeks would be about February 3rd.
Just reminding the court of my medical schedule.
We will.
We can deal with it because there'll be a PSI and so forth.
All right. Anything further from the defense?
No.
Schedule a PSI in this matter?
Yes.
We'll schedule a pre-sentence investigation report, and we'll come back on any motions filed and then for sentence.
Thank you.
Thank you, Judge.
And there you have it. Joseph Ferlazzo Jr., guilty of first-degree murder, again accused of killing his wife, shooting her twice in the head, and then dismembering her body. You're taking a look at the people inside the gallery reacting to the verdict. Obviously, some high emotions there in that courtroom in Vermont. This was a situation where he was significantly older than Emily. They got married in Vermont on the beautiful Lake Champlain. Then they came back there to celebrate their one-year anniversary. He took the stand in his own defense, describing their relationship, which seemed a little bit out of the ordinary, how he was interested in having some other partners, and Emily would get upset with him at these occurrences. And at times he said that she would become violent with him, throwing wine bottles at him and physically assaulting him when he was on the stand. At first he really was describing a lot of the physical violence, but then later on in his testimony he was saying, well, it really didn't hurt me, it just kind of was normal. But you have to wonder, when he was on the stand and he was giving his testimony, if they found it credible, because then the jurors asked to review his testimony when they were deliberating.
Mr. Zarka, if you'll stand, and Madam Clerk, if you will announce the verdict.
Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 23 CR 285987-910. The state of North Carolina versus Tazir Zarka. We, the jury, by unanimous verdict, find the defendant, Tazir Zarka, to be guilty of voluntary manslaughter. This, the 18th day of December, 2024, signed by your foreperson. Is this your verdict? So say you all.
Yes. All right. And Mr. Zark, you may have a seat with your attorney.
Ms. Weiss, if you'll please stand. We, the jury, find the defendant, Amy Jackson Weiss, guilty of count 1, careless driving. Regarding the verdict question as to this count, the jury finds did the careless driving result in death? The answer is yes. You may be seated. People wish to have the jury polled.
No, Your Honor.
Defense. No.
I want to take you into the courtroom regarding Victor Malavit, the defendant in the broken trust abuse trial. This is the one in which the jury's been deliberating 8 hours. We understand perhaps they have a question. Let's go inside the courtroom.
Well, at this time, I've already asked you to further deliberate. Looks like nothing if I continue to ask you to continue to deliberate. So I'm going to be declaring, or I am declaring, a mistrial for all these charges. Members of the jury, I'm going to dismiss you from this case. I thank you for your service. If you don't mind staying in the room for a minute after I step off the bench, I can chat with you about your experience. It'll only be a few minutes, and I'll be right back out for you. So again, thank you so much for your time and deliberation.
All right.
All right, you just heard it. A mistrial has been declared. We knew that the jury had not been able to reach a verdict. They were told they needed to go back and continue their deliberations. They had deliberated 8 hours, 2 minutes. Let's go back into court.
The clerk will send out notice of next steps. We'll probably have a status hearing before we reschedule for another trial. Mr. Malavit, I'm going to remind you that you're still out on bail for these charges. Nothing's changed. We just don't have a verdict. The matter is still pending. And again, you'll hear from the clerk regarding next dates. Is there anything to add for the record before we conclude today?
No, Your Honor, thank you.
Okay. All right. Thank you so much for your time. You both sides did a very good job at trial. And we will see you soon. Thank you very much.
Thank you.
Court stands in recess.
All right, let's bring in our guest, trial and family law attorney Michelle Thomas. Michelle, kind of an interesting way that the court just described to the defendant, even though he's declared a mistrial on all counts. He said, this is still pending. You're out on bail. It's still a pending case. We'll do a status conference. We'll reschedule. It sounds like the judge has kind of assumed that the state's going to retry this man on these charges.
Good afternoon, Judge Ashley, and that's what stood out to me as well, that the court didn't really inquire of the state whether they intended to bring charges or whether they needed any time to discuss it. He just assumed and imposed that same type of expectation on this defendant. And so that's interesting to me, that apparently the court may have thought that there should have been a certain type of outcome and expects the state to go forward, but still it's ultimately up to the state.
Yeah, I agree with you. Now, 8 hours, 2 minutes. I think that that's not an unreasonable amount of time with the jury coming back twice to say, okay, it's a hung jury, meaning they cannot reach a unanimous decision. But I'm a little bit surprised. This juvenile detention facility, a counselor accused of rape, are you surprised that this was a hung jury?
I am, Judge Ashley, because the evidence seemed overwhelming. And let me just say that my heart breaks for this victim who may have to relive the horrifying accounts of sexual abuse that she endured when she was just a child, 15 years old, and tell the story again. I thought she was very compelling, very credible. There was nothing about her that was combative or that seemed as though she was trying to, just take the jury on a wild ride. She simply recounted what seemed to be the facts. The horrifying facts of what occurred and what happened to her. And so I do wonder what was going on in that jury room and what it was for at least one of the jurors that made them say they weren't quite sure and that they believed there was reasonable doubt. It could have been the monetary accusations. Certainly the defense, they tried to allege that she was doing this for some sort of monetary benefit because of the civil cases that were also pending contemporaneously. But I just wonder what it was in that jury room, because I thought she was very convincing and compelling.
I thought she was convincing and compelling as well, but I will say the defense during closing arguments really tried to focus on some of the inconsistencies in her statement, and they pointed out or focused on the fact that she did not report the abuse to the state police until about 6 months later after she filed a civil lawsuit. I don't know if that's what made a difference or not, but clearly not all of these jurors agreed that there should be a conviction for any of these crimes. A hung jury, mistrial declared, and we will wait and see at that status hearing that will be scheduled what the court does next.
Welcome back. We have breaking news in the shot-in-the-back murder trial for Jason Meade that's been happening in Ohio. The judge has called the jury back into the courtroom. This is after he earlier declared a mistrial, retracted it, and then the jury said they were hung again, and the judge sent them back in with a dynamite charge telling them to work as hard as they can towards a resolution. Meade is a former sheriff's deputy. He's accused of shooting this man, Casey Goodson, in the back 6 times without giving Goodson any verbal commands. He faces murder and reckless homicide charges. The judge is on the bench and the jury has just been brought in. Let's get you into court.
Sitting in the same seats the whole time. You've considered this case for a considerable length of time and reported to the court that you are unable to reach a verdict on this matter. The court accepts this conclusion and finds that there is no probability of the jury agreeing. You are hereby excused from further jury service on this matter, and on behalf of the community and on behalf of the court, I want to thank you so much for being such wonderful, valuable citizens. Thank you.
All rise.
You want to keep this word?
And Judge, again, for the record, because I don't think we've put it on the record before, but and of course they're not in here, but to Jill and to Courtney and to Megan and to Rachel and your staff, thank you so much.
And I'll declare a mistrial, and let's get what I'm anticipating is to get a status conference meeting to see when everyone's available for the second trial. Probably. Did you sign a continuance? And then we'll see when everyone's available to set it up for a status conference.
Thank you, Your Honor. You want to walk out with your family, or you want to walk out with your family?
Before we turn to a break in the show, we want to share with you the very latest information on the case against defendant George Kelly. So this guy is accused of murder for the fatal shooting of an undocumented immigrant, but he claimed that he acted in self-defense. The jury deliberations began in the case last week, but they couldn't reach a unanimous decision. And on Monday, the judge declared a mistrial.
Based upon the jury's inability to reach a verdict on any count, the court orders that a mistrial, that this case is a mistrial. The court will set a status hearing for next Monday on the court's usual law and motion calendar for 1:30 to allow the state to take a look at the situation and decide whether or not it wishes to ask the court to reset the matter for trial.
So right now, Kelly just wants to go home, and we're going to continue updating you on his case. We'll wait and see whether the state chooses to try him again.
All right, folks, get ready. We're about to deliver you the verdict in the Delphi murders case. Barbara McDonald, Court TV senior producer, on the ground, was inside for everything. Barbara, we've been waiting for this moment. Please deliver the verdict.
Guilty on all 4 counts, unanimous by this jury. The defense did ask to have the jury polled. They all affirmed that that was, in fact, their verdict. Guilty of 4 counts of murder, 2 counts of felony murder against Abigail Williams and Liberty German, 2 counts of intentional murder against Abby and Libby. Sentencing will happen on the 20th of December. The judge is setting aside all day. I can tell you when we got into the courtroom about 10 minutes till 2, it was somber. Very quiet. Nobody was talking. The room was filled with members of law enforcement, Indiana State Police, the Carroll County Sheriff's Department. Abby and Libby's families were already inside the courtroom when the media was allowed in, and the Allen family was not present. The media members came in, took their seats. There were 14 seats available to the members of the general public. They were then brought in. Bradley Rosie and Jennifer Auger from the defense team were not in the courtroom. Richard Allen was. He was standing at the beginning talking with his defense attorney, Andrew Baldwin. The judge came in just after 2 o'clock and asked where Mr. Baldwin, or rather where Mr. Rosie and Jennifer Auger were, and the judge entered at 2:11, according to my notes. And Andrew Baldwin told the judge that they were waiting for Kathy Allen and members of Richard Allen's family to arrive. The judge said, so despite my directive to be less than 10 minutes away, she said the jury has reached a verdict. When can we expect them? Andrew Baldwin replied they were on their way up. They entered the room at about 2:14. At 2:15, the jury, or rather 2:19, the jury entered. You could not tell from the looks on their faces. They did not make eye contact with Richard Allen or either family members of the victims, Abby and Libby, or Richard Allen's family. They came in, they sat down, they looked weary. And again, the room was absolutely quiet. The judge had admonished the crowd not to have any outbursts, that regardless of what the verdict was going to be, there were going to be people who were going to be unhappy with it. She said you can take your unhappiness outside of the courthouse. Again, this jury finding Richard Allen guilty on all 4 counts of murder that he was facing after about 18 hours of deliberations over 4 days, Vinny.
So at the moment he's found guilty, everyone admonished not to say anything, not to react. What did you notice anything in the courtroom? Anything from a family member to Richard Allen?
Yeah, so his wife and mother, his wife Kathy and his mother Janice began sobbing. The people who were sitting around them hugged them, held them. They were audibly sobbing through most of the proceeding once that verdict was announced. There were members of Abby and Libby's family that were crying. There were others that just remained rather stone-faced as the verdict was read, and that immediate reaction. Once the sentencing date was set, the judge did say that we were free to leave. The law enforcement in the room allowed Richard Allen's family to leave first. After Richard Allen was outside of the court, he was immediately taken into custody. Obviously, he's been in custody, but that will change soon for him. Then the Allen family was allowed to leave, as were members of Abby and Libby's families. Some of their family members stayed to give hugs to members of the prosecution team, to Superintendent Doug Carter of the Indiana State Police and Lieutenant Jerry Holman of the Indiana State Police, as well as the prosecutor, Nicholas McClelland, Stacy Diener, James Luttrell. A bit of a celebration in court, although they weren't being very loud with that celebration. I was on the opposite side of the room, but there were a lot of hugs going around, a lot of pats on the back. The prosecution, though, remained somber looking throughout this entire proceeding today. And again, you know, it was just very, very quiet in the courtroom. It was really the first time that I've been in the courtroom with all of these people, and you could hear a pin drop. A lot of reaction outside. I came out of the courthouse. I was one of the pool reporters today, so I did have my sign for the members of the media who were not in. And as people began to see this and realize what the verdict was, there was a lot of cheering, a lot of screaming for Abby and Libby, a lot of clapping. A lot of people are very happy with this verdict. Of course, not everyone is. Richard Allen's family appearing to be quite surprised by this verdict. The judge did also mention that the county, Carroll County, is not able to do that pre-sentencing report for Richard Allen. She had already talked to people from her county who are willing to do that. The defense did waive the 30-day sentencing, which is typical here in Indiana for sentencing to happen in December. Again, it'll be December 20th. They think they only need 1 day for that, and the judge has set aside the entire day. That is a Friday, December 20th. We'll be back here in Indiana to find out just how many years he's facing. Right now, he could be sentenced to 130 years or more.
All right. Verdict Form 1 reflects that we, the jury, find Alec Ray Jones guilty of the crime of murder in the first degree. Is this your verdict? Yes. I'm just going to ask you individually, starting in the back row at the left, if this is your verdict. And I'll just start with you, sir. You, sir? You, ma'am? You, ma'am? Sir? Yes. All right. Thank you, ladies and gentlemen.
Dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teske gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state. Quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you, Ron.
We are in recess. I'm not getting up. I'm gonna.
Dismiss him, Judge. Dismiss him.
Go ahead.
Thank you all for your help.
Okay, counsel, if the defendant could please rise. And I will read the jury's decisions. For verdict form 1, count 1, aggravated murder, State of Ohio versus Erica Stefanko, we, the jury, being duly impaneled and sworn, find the defendant, Erica Stefanko, guilty of the offense of aggravated murder as charged in the indictment occurring on or about June 20th, 2012 through June 21st, 2012. And I do have 12 signatures. This says we do so on January 31st, 2024 with 12 members of our jury concurring. On count 2, murder, we, the jury, duly impaneled and sworn, find the defendant, Erica Stefanko, guilty of the offense of murder in the commission of an offense as charged in the indictment occurring on or about June 20, 2012 through June 21, 2012. We do so on January 31st, 2024, with 12 members of our jury concurring.